We're going to get started in just a minute. Okay, it's 8:45 and we're going to go ahead and get started. For those who don't know me, my name is Ryan DiClemente and I am the co-chair of Saul, Ewing, Arnstein, and Lair's Consumer Financial Services Litigation Practice. And we are pleased to have you join us for our third annual half-day CLE seminar, which is Significant Developments in Consumer Financial Services Litigation and Enforcement. Now, this year's program is going to be a little different. I'll be missing seeing everyone in person. However, during this tough time, my wife and I have been looking for positives, as difficult as that may be, and we call those positives COVID pluses. So for example, having dinner with my wife and kids every night has been a real COVID plus during this time. When they opened up golf courses here in New Jersey at half capacity and gave everybody a cart, you were allowed to finish a round in 3.5 hours. That was definitely a COVID plus. Well, this year's panel and presentation is definitely a COVID plus. We have 100 participants from across the country and a great slate of speakers from Ohio, South Carolina, Tennessee, and Maryland. Our terrific panelists will examine recent developments in consumer financial services regulations, such as the Fair Lending Act, the Telephone Consumer Protection Act, the Fair Credit Reporting Act, and we also have a terrific in-house counsel roundtable discussing the impact of COVID-19. Now, before we begin, there are a few housekeeping announcements that I have to run through. Questions can be submitted through a Q&A tool at the bottom of your screen. And while we'll do our best to answer all of your questions submitted during the webinar, should we run out of time, we will follow up individually via email. Today's program has been approved for distance learning CLE credits in Pennsylvania, New Jersey, Illinois, and Delaware, with applications pending in Florida, Minnesota, Ohio, and Virginia. Now, as a CLE provider, we must be able to verify your attendance. Therefore, at random points in the webinar, we will display and verbally announce 3 numeric reporting codes that you must record and report back to us using the CLE survey that you received in your webinar reminder email. We will in turn send you a certificate of attendance once we receive your survey responses. Now, please be sure to respond to the CLE survey with your numeric codes within 5 days of the program. Following the webinar, you'll also receive a thank you for participating email that will include links to the webinar recording and supplemental presentation materials. And finally, what would a good CLE be without a good legal disclaimer? So here goes. The provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, although we'll be happy to form one after the CLE, and should not be acted on without seeking professional counsel who have been informed of the specific facts. So with that, let's begin. And I'm very happy to introduce our first presenter, Evan Foster, who is a partner at Saul, Ewing, Arnstein, and Lair. He is also the vice chair of the cybersecurity and privacy practice, and he will be providing our cybersecurity and data protection update. And with that, I will turn it over to Evan. Thanks so much.
Great, thanks a lot, Ryan, and thank you everybody for joining us this morning. This is going to be an exciting program, and we appreciate everybody's attendance. As Ryan said, I'm Evan Foster. I'm going to be providing a cybersecurity and data protection update to everyone. I would ask that everybody please hold your questions to the end, although you can submit them using the Q&A feature at the bottom of Zoom, and we'll try to get to as many as we can. If we could go to the first slide. So the topic for today's discussions, I'm going to be giving an update on the California Consumer Protection Act, which just went into effect at the beginning of 2020. I know that many folks on this call may have already been dealing with that at least this year and probably before that, but that sort of provides sort of a foundational update for the next topic, which is going to be the CPRA, which is a relatively new statute that was just passed in California earlier this year. And then finally, I'm going to give a brief sort of look ahead discussion about where I think cybersecurity and data protection challenges are going to arise in 2021 and beyond. So if we could start off, just for many of you may already be familiar with the CCPA, but for those who are not, I thought it would be helpful to provide a quick background. So the CCPA is a California law that applies to the collection and use of personal information of consumers. As I said, it went into effect in January 1 of 2020. And in addition to sort of adding numerous compliance challenges and compliance requirements, for our purposes, one of the main reasons to pay attention to it is the massive potential for class action damages for violations, which can be up to $750 per class member. So that in and of itself is a reason that everybody should be familiar with CCPA and be paying attention to CCPA compliance. As shown on the next slide, the CCPA applies to any for-profit business that collects personal information on California residents. And then there are some thresholds that I've stated here: annual gross revenue of at least $25 million, companies that buy, sell, receive, or share information of 50,000 or more consumers, households, or devices of California residents, or that derive at least 50% of their revenue from selling information. I think one of the really important pieces, and a question that we get asked all the time, is whether or not CCPA applies to businesses that are outside of the state of California. And the answer to that question is yes. Even if you don't have a physical presence in California, it applies to companies so long as they have personal information of a resident of California. So that's one thing that often trips up companies who maybe aren't as familiar with this, who may be operating a web presence, or again, may not have a physical presence. But so long as you have information, personal information of California residents, the CCPA applies if these other thresholds also apply to you. Just so everybody is clear, for CCPA purposes, personal information is defined pretty broadly. And it includes any information that identifies, relates to, describes, references, or is capable of being associated with, that could reasonably be linked with, whether directly or indirectly, a particular consumer or household. So that's a mouthful, but as you can imagine, that can really sweep in a lot of different information, even though it may not on its face seem to be personal information. So some of the kinds of things that you may need to think about that are considered personal information that may not immediately jump off the page: any kind of unique identifier, which could include an IP address, could include an ID number that is linked or traceable back to an individual or household or a device. Electronic network activity information, which may include browser history, search information, cookie information, or any information regarding a consumer's interaction with a website or advertisement or software application. Audio, electronic, visual, thermal, and obviously biometric information, to the extent, again, it's capable of being associated with an individual or household. And geolocation information, so where a device is physically located, may also be considered personal information for CCPA purposes. It is also important to note, however, that at least as of right now, personal information relating to employees, job applicants, business customers, and service providers is not considered personal information under CCPA. But as we'll talk about later, that will change, and there have been numerous amendments to CCPA that will kick in that will change that. So what is out of scope? As shown on the next slide. So there's a fair number of exceptions to CCPA and what information is not covered. So for purposes of this group, probably most important for purposes of this group, personal information that is otherwise subject to GLBA or the California Financial Information Privacy Act is out of scope for CCPA. So obviously that takes some burden off of consumer financial services companies for CCPA compliance. However, there is even an exception to that exception. And the most important one being that California residents can still file suit for breaches of non-encrypted or non-redacted personal information, even if it's otherwise subject to GLBA or the CFIPA. So that really creates some compliance headaches, because it means that your CCPA compliance program still needs to take into account that information for purposes of breach notification and for data mapping and data inventories, even though you may not necessarily need to otherwise have CCPA compliance practices for that information. I'll also say that what we'll talk about in a little bit is you also need to remember that just because the personal information of consumers that might fall under GLBA or the CFIPA is not included in CCPA compliance, employee data or other data that you may have may be included in scope of CCPA. Next slide, please. So what does CCPA do? It established, among other things, a basket of new rights for California residents. So here's a couple, which I'll sort of go through quickly. California residents now have the right to know the categories and specific elements of personal information that companies are collecting about them. So that means that there needs to be some kind of notice and disclosure that sets forth all of the types of information that a company may be collecting on an individual. The individual has the right to go out and obtain a portable copy of that information, meaning you need to have a process in place for if a request is made, you need to be able to collate and collect that information and provide it, likely electronically to the requester. The California resident also has a right to request deletion of the information that a company holds on them. So again, you need to have a process in place that allows and sort of mechanism in place that allows for deletion of that information. And then California residents have the right to opt out of the sale of their personal information to third parties, subject to some exceptions. But then when we talk about the CPRA, we'll talk about how that even is going to be modified. Next slide, please. So the other thing that CCPA does is it imposes some pretty significant obligations and responsibilities on businesses, which are sort of consistent with some of these new rights that it establishes. So first and foremost, it requires businesses to have a process and a capability to verify and respond to these consumer requests. So if a consumer requests the deletion of their information, or they request to know the categories of information that a business is collecting, CCPA requires businesses to have a mechanism and process to be able to respond to those kinds of things. So obviously that's significant because it means that you obviously need to know all of the categories of information that are being collected, how they're being used, who it's being shared with, which may seem easy at first, but that's not necessarily the case. Second of all, it requires businesses to be transparent about their data collection and usage practices. One of the first elements and what I find clients are still sort of struggling with is just having privacy notices in place prior that are presented to consumers prior to the collection of their information. And this is the case not just for websites, but sort of in all aspects of places where companies may be collecting information. So it could be a mobile app, and it even can include offline collection, which is something that I think a lot of companies haven't yet realized, is that the privacy notices need to extend beyond sort of online collection and includes offline collection. There needs to be a California specific description of the consumer's privacy rights. So you may have seen this. A lot of sites now include a specific link or a specific portion of their privacy notice that sets forth your California privacy rights that go and enumerate all the things that CCPA requires. So again, that has been a threshold matter that companies have had to go and sort of update their notices and update their websites to include these California specific requirements. And finally, and this one I know has caused a lot of heartache, there needs to be a clear and conspicuous link to a do not sell my personal information webpage where California residents can go and submit a request for the business to not sell or not engage in the sale of the resident's personal information. So again, not just having the web page and not just having the link, but you need to enable and facilitate a process to actually effectuate that. CCPA requires that businesses have contracts in place with their service providers to bind them to CCPA compliance and ensure that if the business is subject to CCPA, then the service provider will also be subject to CCPA and will treat all of this information in the same manner that the business is required to. So again, that's another area where the CCPA can have sort of extraterritorial application, because even if you are a company in New Jersey, for example, but you're doing business with a company that requires CCPA compliance, you can be brought in by contract to have to comply with CCPA. CCPA also requires the businesses who are responsible for their company's CCPA compliance are trained in all of the various compliance obligations and understanding the responsibilities of the business as it relates to the privacy rights of California residents. And then finally, CCPA also imposed a requirement that businesses maintain reasonable security procedures and practices that are appropriate to the nature of the information. And this one is significant because sort of for the first time, the California AG's office actually sort of put out some guidance as to what they might consider to be reasonable security procedures and practices that actually are a little bit prescriptive in that they identify the types of things that companies should be doing to collect and secure certain personally identifiable information. So that is sort of a shift, and actually another question that we often get, well, sort of what does that reasonable security mean? Well, CCPA and some of the guidance from the California AG has actually gone in and stated that. So if we go on to the next slide, the CCPA has only been, on the books now for almost a year. But if you're all familiar with the statutory history of CCPA, you know that it was enacted in sort of a little bit of a scattershot way and in reaction to a referendum that was actually put forward in California. So when it was actually passed, the text of the CCPA leaves sort of much to be desired. As a result of that, there have been numerous amendments since it was adopted, and some of them were really sort of cleanup amendments to fix drafting issues or to clarify things. But there have also been a fair number of actual substantive amendments, and I've identified some of them here. The first was to clarify that publicly available information would not be considered personal information under the CCPA. Obviously, that's important. Phone book directory type information is now excluded and carved out. There's also an amendment that extended consumer information to include any kind of biometric information. So again, being cognizant of sort of the broad definition of personal information, there was an explicit amendment to include biometrics. There was an amendment back in, I believe, September that accepted from the definition of personal information certain categories of medical and health information, including information that may be covered by a HIPAA business associate agreement. So that was helpful for companies who are operating in the healthcare medical space. And there was a fairly recent amendment that extended the exemption for employee information from CCPA until January 1, 2022. That's important because as folks have mentioned, or folks have been concerned about whether or not the information on all their employees would then be subject to CCPA, which obviously for some of the things I've mentioned in terms of the right to be deleted and no sharing and other kinds of things makes things very very difficult. And finally, just sort of from a timeliness perspective, even just last week, there was the state AG's office proposed an additional amendment that sort of does two primary things. It imposes a uniform do not sell button that would be required for the bottom of every application and website to sort of align with that, do not sell my information. So they're proposing sort of a standardized button or graphic that would need to be included. So obviously, if that goes forward, that's going to be sort of an additional burden to make sure that gets added to every website and app. And it also clarified that California expects that there would be a mechanism for offline notice for offline data collection. So if you are collecting information via paper, for example, this amendment sort of clarifies that you would also need to provide some kind of paper privacy notice at or before the time of collection to define persons' rights under CCPA. So obviously, again, that's pretty significant and would require modifications to process. So now moving on to the next slide. So if all that sort of weren't enough, just in November, California voters approved sort of an expansion and refinement of CCPA, the California Privacy Rights Act. So this does not go into effect until January 1 of 2023, but the CPRA expands and extends both the CCPA rights for California residents as well as the obligations on businesses. And the other important thing that CPRA does is establishes a separate California Privacy Protection Agency, which is going to be charged with overseeing and implementing CCPA and CPRA. So what does CPRA do? Well, on the next slide, we sort of talk about the new and expanded business obligations under CPRA. So the first and maybe significant, it requires pre-collection privacy notices, and it goes into great detail about what specifically those privacy notices need to say. So I've outlined here the categories of the information that needs to be included. I won't sort of go into them in sort of more detail than what's here. But I will say sort of a couple things which are sort of expand on what's required under CCPA. So number one, and very similar to GDPR, businesses are now required to identify the categories of sensitive personal information that they may be collecting. Number two, the business needs to identify whether or not they're selling or sharing personal information. And they also need to identify the purpose for the collection or use of the sensitive information. So all those three things are sort of new requirements that CPRA adds. There is also sort of an interesting new limitation on the use and processing of all personal information, whether sensitive or not. So now CPRA requires that any collection or use, retention, or sharing must be reasonably necessary and proportionate to achieve the purpose for which the information was collected. So no longer is it sufficient to simply say, hey, we're collecting this information, but now there is a requirement that basically the use or processing of that information is justified. And it's somewhat similar, we think, to kind of HIPAA's minimum necessary standard, which basically says that, this can't be a fishing expedition, if you will. You can only collect and use information, sort of with these kind of limiters. And it will be interesting to see how regulators approach that reasonably necessary and proportionate standard. So that's something to keep an eye on. There are some other, go to the next slide. There's some other expanded and additional obligations. So there now needs to be a written agreement. Businesses need to have a written agreement with all third parties with whom they sell, disclose, or share personal information. And that agreement must specify the following things. So the purposes of the disclosure obligates the counterparty to comply with CPRA, which again, that's pretty consistent with the CCPA's current requirements. Gives the disclosing party the right to take reasonable and appropriate steps to ensure compliance by the counterparty. And it's not clear as to what exactly that means, but the implication is that gives the disclosing party, the right to audit, or at least, conduct some inquiry on how the recipient is using information. And then it also requires the recipient to notify the disclosing party if it feels that it can no longer comply with CPRA. Second, the CPRA further requires that businesses implement reasonable security procedures and practices, not only to just protect the information, but also protect it against loss. And loss can be defined fairly broadly in that context. And I think it doesn't necessarily just mean a data breach, but also could even mean sort of operational type issues like a data center destruction or data center failure. So again, additional requirements, additional process, additional technology may be required there. And then the CPRA further expands the CCPA requirements for what need to be included in privacy policies. Again, I won't sort of go through each of these, but you can read here what the additional requirements need to be. Go to the next slide. So in addition to expanding the obligations on California businesses, CPRA also expands the California residents' rights under CCPA. So again, CCPA adds rights for California residents to request deletion of personal information and provided businesses with a right to object to those deletion requests under certain circumstances. So for example, under CCPA, a business could request or could reject deletion of a request if they were using the personal information to detect security incidents. So for example, if they needed to retain IP address information to track down a ransomware or some kind of hacking attempt, if a deletion request was made, a business could reject that request on those grounds. So under CPRA, however, that exception has sort of been narrowed. And so now the business can only refuse the request if the information is reasonably necessary to help ensure security and integrity. And again, there's a reasonably necessary and proportionate standard. So it's not sufficient under CPRA, for example, to retain years and years of log information that might include personal information if you know that an attack happened within a discrete period of time, for example. So that will be interesting, that sort of reasonably necessary and proportionate standard, and how that ultimately will shake out. And similarly, previously under CCPA, a business could reject a consumer request if the business wanted to use personal information for internal purposes, so long as that internal purpose was aligned with the consumer's intent at the time the information was disclosed. CPRA has completely eliminated that basis for rejection. So now if a consumer says, please delete my information, the business, at least under this particular prong, has to comply with that request. There's no sort of internal use exception. And finally, CPRA also adds an ability and requires a process for if a consumer requests correction of inaccurate personal information, the business has to have a process to be able to respond to that request and make corrections if appropriate. And so, again, this is going to require businesses to adopt processes and procedures to ensure that, if it receives a consumer request, that it's able to sort of timely and accurately respond and identify the information that it's corrected. So finally, I wanted to, if we go to the next slide. So there's also some additional expanded rights with respect to sharing and sale of information. So now CPRA affirmatively requires California businesses to explain whether they are sharing personal information. And so, for example, that may include whether they are disclosing personal information for behavioral advertising purposes or for retargeting purposes. As I mentioned, it also allows California residents to opt out to the sale or sharing of their PI, with only very limited exceptions. It gives the residents the ability to limit a business's use and disclosure of sensitive PI. And again, there are very few exceptions to that. That's a fairly broad ability to do that on the part of the residents. And then finally, it imposes an express obligation that businesses cannot retaliate against individuals who opt out or exercise of their CPRA rights. So for example, if you request a business delete your information, or you opt out of sharing, a business can't now charge you additional money, or can't require you to pay more for a product, or can't deny you access to a particular good or service. So all of those are sort of new obligations under CPRA. So in the last minute or two, I thought it would be helpful to just provide some context from sort of what our group thinks in terms of looking ahead. So even though 2020 has been a fairly active year in terms of FTC enforcement activity in the data privacy space, so obviously we just had a pretty significant FTC settlement with Zoom here in the fall. As you may have heard, within the last week or so, the FTC and 48 state AGs, launched a giant action against Facebook. We think it's probably likely that that activity is going to continue, if not become more aggressive. Although it's unclear whether or not the current FTC chair is going to remain on or going to step down at the start of the Biden administration. We think there's going to be a continuing focus on biometric information and use of biometric information, as well as enhanced concerns about artificial intelligence processing of information and how that is going to be used, and some enforcement action relating to sort of automated processing or targeting of personal information. We're also seeing, now that some of these state statutes like CCPA or Reg 500 in New York have become more mature and have become, are on the books for a little while now. We think there's going to be increased enforcement activity there, as I think probably many of you know. Over the summer, there was the first enforcement action by NYDFS in New York relating to Reg 500. Well, we think there's going to, be an uptick in that, particularly as now some of these effectiveness periods have sort of expired and the statutes have come into full effect. And finally, just trying to crystal ball a little bit, the impact of the Biden administration. I think the consensus of our group is that there's going to be increased focus on federal privacy legislation. And that's obviously been talked about a great deal over the last few years, but that seems to be a potential showcase of Biden's platform. And so we think that there are increasing prospects of that actually coming to fruition during the Biden administration. And then also, as many of you know, the Schrems II decision that invalidated the EU-US Privacy Shield. And obviously the Trump administration didn't have a lot of desire to work with the EU to reestablish that. But we think, maybe as part of re-strengthening ties with Europe, that may be something that the FTC and Biden's cabinet will look to do in terms of reestablishing appropriate protections for Privacy Shield. So with that, I think I'm right at time. I think there's one question, but I think given we're a little over time, maybe I'll try to respond to that over time or offline.
Great, thanks so much, Evan. That was true.
You're very welcome. Thanks, Ryan.
So first, before we get started on our next presentation, we have our first code. So you want to write this down. This is for CLE purposes. Code number 1 is 35213. 35213. Next up, I am very pleased to introduce Prabir Chakrabarty. Prabir is the Vice President and Associate General Counsel at Mariner Finance, LLC, where he handles various issues for the company, including compliance and litigation matters. He's also the Program Chair of the Financial Services Network of the Association of Corporate Counsel. And Prabir also serves as the Diversity and Inclusion Chair for the American Financial Services Association. Prabir and I are very pleased to present the next presentation on developments in Fair Credit Reporting Act regulation and litigation. Next slide, please. So credit reporting issues continue to be a significant focus for regulators and one of the top, if not the top, basis for consumer complaints to the CFPB. We will discuss a recent consent order with the debt buyer, AFNI, and some takeaways from that order. From a litigation perspective, Fair Credit Reporting Act cases continue to increase. According to WebRecon, which tracks federal court filings, FCRA cases have increased more than 5% this year. September and October have shown a 9 and 11% increase in Fair Credit Reporting Act filings. Personally, my practice has shifted significantly to defending these cases over the past 2 to 3 years, and there is no sign of slowing down at this point. This year, there's even more complexity and uncertainty injected into the industry with the enaction of the CARES Act. Now I'm going to turn it over to Prabir to talk and discuss the CARES Act and some of the ongoing challenges with the implementation of this act.
Thanks again, Ryan. And not sure how my picture still shows up on the Zoom, but that is actually from an event that I was invited by another partner of yours, Indra Sharma. So there's a Saw-You connection on that. Yes, the CARES Act, I think obviously in the face of a pandemic, it was, government was trying to, the legislature, then CFPB, there was a lot of things that were out there that, that we thought may happen, but the CARES Act seems to be a compromise And you know, what it really went through and what it covered was, you know, the treatment of people who were affected by COVID during that 120-day period of the national emergency. And you know, what they did really is go back and suggest that you use the same coding. I don't know if that's on the next slide, but that they use during national emergencies, which is an AW code. And you know, that in and of itself was quite a challenge for the industry, because you know, we had experience with that code before, and it's not necessarily something the credit reporting agencies considered it you know, neutral in its application. But you know, we had I know a colleague who has a lot of branches in Houston, and when they had flooding, they put the AW coding on every account, and then soon thereafter they started getting complaints based on that coding, because lenders weren't quite sure what that meant as far as you know, how it affected their credit. So you know, what it points out is a lot of uncertainty, and as you said, Brian, a lot of you know, avenues for consumer rights attorneys to bring actions, as well as regulators, as you point out with the AFNI consent order.
That's great. So have you continued to struggle with any additional implementation issues, Prabir, as it relates to CARES Act, or do you think you've kind of moved through the beginning portion of it?
I think we have done the best that we can under the circumstances, and really the obligation from the compliance angle is to show what the plan was, document the plan, make sure that you know, if somebody does come back on the back end to question any portion of that, you have a clear delineation of the steps you took, and then, you know, if there are situations where you didn't fully you know, where there may be complaints, you at least have that defense. But no, it's a challenge every day. And you know, one of the interesting challenges on the AW coding in and of itself is that it is not sort of time specific. There's no timestamp. So for all of those people who you know, had that coding of the AW on there, at some point it's gone. And at least from credit reporting perspective, there's nothing to show future lenders that they had the coding on there, which is a challenge in and of itself. So yeah, no, we continue to face challenges, and I think you know, as we hopefully move past the pandemic, we're going to start to see, you know, a much greater understanding of the full impact of this.
Okay. Thanks, Prabir. If we can move to the next slide. So, I mean, we operate from the understanding that CARES Act has been in place for a while now, and that most of the group will understand its general framework. One takeaway that I thought was important, as highlighted by the CFPB through its FAQs, was that, you know, we're really talking about ensuring that an account is reflected as current for any accommodation. And in the FAQs, the CFPB specifically highlighted that all of the trade line information they furnish that reflects a consumer's account as current or delinquent must be updated. So that includes account payment status, scheduled monthly payment, and the amount past due. So that is, it is not just a single change to the account. You must be changing the account to make the account be consistent across the board for payment status, scheduled monthly payment, and the amount past due. Prabir already talked about the special comment code, but it's important to note that just the application of that code alone, that special comment code, is not going to be sufficient or a substitute for complying with the CARES Act regulations. We have attached, next slide, the CDIA came out with some guidance on this that we wanted to highlight, but didn't want to really spend time talking through just because of the time limitations. But I thought that this was some good guidance that came out over the summertime. If you haven't seen it, it kind of picks up and addresses the CFPB's FAQs and addresses what to do with accounts that were current prior to accommodation, as well as accounts that were delinquent prior to accommodation. I can tell you that one of the areas that I've seen clients struggle with is when it comes off the accommodation period, how not to advance the delinquency period. So according to the CFPB, that if it came into the accommodation period at 30 days and there was a 2-month period of accommodation, if it comes off the accommodation period, you cannot advance it. It must pick back up at 30 days. That's been a real challenge for a number of clients. And Prabir, correct me if I'm wrong, I don't think that the industry has a real good answer to that yet.
No, hypothetically, of course. No, I think, no, you're absolutely right. And data first delinquency is a challenge in and of itself, but to sort of suspend reporting for a period of time, but not advance data, the data first delinquency, or not to show the delinquency. It's a challenge. And, obviously, if you have many customers, the challenge only goes up with the size of your organization. So it's something that's you're constantly working on, and again, to come up with a systemic plan and make sure that you're updating your policy and procedures and your specifically your credit reporting policy and procedures to make sure that you're complying with these things is a constant challenge.
Yeah, and I think the industry to work with its trade associations to get some additional information from the credit reporting agencies about how to deal with these technological problems as it relates to implementation in the post-accommodation period. Because I think that this is something that's going to continue that companies are going to struggle with. Moving to the next slide. So the CFPB, when this CARES Act was first implemented, originally identified kind of a flexible supervisory and enforcement approach during the pandemic. It kind of indicated an understanding of the challenges that companies were facing with the remote environment, the challenges perhaps companies were facing with meeting the 30-day period. After that statement came out from the CFPB, certain state AGs cautioned they're going to continue to enforce. And as we'll see shortly, the CFPB hasn't really stopped enforcing the Fair Credit Reporting Act either. So while there was originally kind of this idea that there would be more of a relaxed enforcement environment, personally, I think we're past that point at this point. I don't see the CFPB having a relaxed approach. I think now we're at month 9. I can't believe I'm saying it, but we are. So I think regulators are going to believe, as difficult as it is, that that the implementation period, we're past that. And I don't see a tremendous amount of flexibility, notwithstanding the CFPB's original statement from an enforcement perspective. Next slide. So this is a consent order that Prabir and I wanted to focus on. And the next kind of remaining pieces of the presentation, we're going to talk about the specific enforcement action and some litigation developments. As we mentioned previously, the CFPB remains focused on credit reporting. I want to discuss a consent order that was recently entered between the CFPB and AFNI last month. AFNI, for background, is a debt buyer who specifically focuses on the purchase of telecommunications debt. And the consent order is interesting because it focuses exclusively on FCRA violations and inadequate policies and procedures that the company had. Specifically, the CFPB noted, among other things, the failure to report the data for first delinquency. The CFPB noted that AFNI identified other dates such as the date the account was first assigned to AFNI as the date of first delinquency. The CFPB also focused on inadequacies in AFNI's investigation process after receiving both direct and indirect disputes. There's some specific takeaways that Prabir and I want to kind of focus on. The first is the CFPB took issue with the automated process used by AFNI for its investigations and specifically noted there was no human involvement in these investigations. Now, I think while I believe that AI and other automated functions have a place in the review process for furnishers, there are still difficulties in creating a reasonable investigation that is fully automated. So for example, I think that AI or automated technologies could be used to quickly search account notes for certain keywords that are relevant to a specific dispute, or quickly sift through large amounts of data. This could be used to assist reviewers in highlighting and identifying certain specific issues for their review, but a fully automated process presents a more difficult question. Prabir, would you agree with that kind of assessment of that?
Yeah, that really was my take of the consent order, and the fact is what the challenge is for everybody who does reporting is credit, quote unquote, repair organizations. So you get direct disputes, these letters that are form letters that everybody, that all of these credit repair organizations are using, and they're sending them from, multiple locations, sometimes from the same location from multiple customers. And the flood of them is really the challenge here, because you get so many of those that trying to sift through and find the ones that are actually important is really the challenge. And, so I feel for AFNI in this, and that they tried to use an automated solution to try and assist with that. And I think, a lot of companies are looking at that. But the bottom line is, as CFPB points out in the consent order, is that is not a substitute, as you said, for human involvement. You can't use that as a crutch to say that we've looked at it and we don't need to examine these disputes. And it's a challenge. It's a constant challenge. And I've been to a number of presentations from the CDIA, which is organization for the credit reporting CRAs, and it is something that is brought up to regulators and to Congress all the time, but it's just the credit repair organizations it's a constant challenge for furnishers.
Yeah, and I do want to highlight just this as well, which is that the CFPB also noted that when they received disputes, AFNI did, it could not be investigated based on the limited information in their files. It did not reach out to the original creditor for the information required. This comment, out of any comment in the consent order, concerns me probably the most, because of the impact it could have on the industry if applied to larger industry participants. So for example, if you're an auto finance company, would you be expected to go back to the dealer and get the dealer's file prior to responding? If you're a credit card servicer or a student loan servicer, do you have to go back and get information from your retail partner or the schools who originated the debt? I mean, think about the impact and the significant strain that it would put on response times. Now, I'm hopeful that there were a few mitigating factors that led to the CFPB's decision. Now, as a debt buyer, I don't believe that AFNI had a robust servicing or origination files, and the CFPB noted the limited information maintained in their files. So I would hope that the CFPB would look differently upon more traditional servicers and finance companies, but this is something that's definitely worth monitoring, because I don't believe that I ever understood that you needed to go outside of your servicing files or outside of your own files to conduct what was believed to be a reasonable investigation.
That's an interesting take, Ron, because because it is a debt buyer, are they holding them to a higher standard? We are an original creditor, so it's a little bit easier, but we do get assignments of notes. So that's a really interesting point.
Yeah, and I think we're going to have to kind of see how this plays out with future consent orders, and see if this is now a theme and a new expectation, or whether it was a one-off because of who AFNI was and kind of the limitations within their own files. If we could move to the next slide. So the next development I want to highlight is a new class action that was filed originally in California State Court, arising from, among other things, violations of the CARES Act. Now, this is something that we've kind of been waiting for, and I think this is just the very, very tip of the iceberg that we're seeing, because I think most of counsel who deal in this space are expecting kind of an influx of CARES Act related litigation. So this is a putative class action that alleged that the mortgage servicer violated the CARES Act by reporting loan payments subject to a forbearance agreement during the pandemic as late or deficient to CRAs and other third parties. And I'm not going to go through, we kind of just highlighted the specifics of this. I can tell you that there was an amended complaint that was filed on Thursday. No response has yet to been submitted, but I would fully expect we're going to see a motion to dismiss. And again, this is going to be a development. This is one of the first larger cases that have come down and been filed relating to the CARES Act. I do think that there are specific issues here, that it's not just the inaccuracy based on the CARES Act, but rather because there was a forbearance agreement in place. I think that may change and create additional difficulties for SLS to get out of this on a motion to dismiss stage. But one of the things that this case made me think about, and we're going to talk about it in a few minutes, is that for those FCRA claims that are alleged only an inaccuracy based on the CARES Act, such as where the act required an account to be reported as current, where it otherwise would not have been, there's an interesting argument that this is not a factual inaccuracy, but a legal one. And legal inaccuracies are not actionable under the Fair Credit Reporting Act. And this is one potential defense that I'm really interested in monitoring over the coming months, particularly with what I'm going to talk about in a couple minutes about some developments out of New York and some other states. Prabir, do you have anything on, kind of the CARES Act potential litigation?
Yeah, I unfortunately, I think you're right that this is kind of the tip of the iceberg. I think, obviously, in and of itself, bringing a FCRA claim has, challenges, because it is, what starts the liability for the furniture is that notice from the CRA, and in and of itself, that is always a challenge. But when it comes to forbearance, when it comes to obviously CARES Act, it just adds to complexity.
Yeah. If we could advance 2 slides, that's great. So this is kind of what I was talking about that dovetails with the CARES Act litigation. So there's a recent line of cases dealing with disputes regarding debt status. And most recently, there have been a number of cases brought claiming an inaccuracy where a furnisher reports a debt as charged off, but is still reporting a past due balance. And in some, plaintiffs are claiming that there should be a 0 past due balance because debts cannot be collected any further because they have been internally charged or written off. Now, if you're saying to yourself, how can this even be a claim? I had the exact same reaction, but yet these cases continue to be filed. It was surprising to me because it's just so counterintuitive. Obviously, we practice in the industry. We know that simply because a debt is written off or charged off for accounting purposes doesn't mean there's no past due balance, or doesn't mean that it can't still be collected on. But yet, this is a new theory. This is not a single case. This is literally dozens of cases being filed across the country with this same theory. However, I have positive news to report. Recently, in the past few months, there have been a number of cases rejecting these claims on a motion to dismiss, especially out of the Eastern and Southern districts. As you would expect, courts have rejected the premise that charging or writing off a debt precludes a creditor from later collecting on the subject debt. And in fact, decisions have noted that creditors may actually be required to charge off these debts pursuant to federal regulations and or for accounting purposes. Courts have also reasoned that these types of challenges or disputes are legal disputes, not factual disputes, which are not actionable and cannot serve as the basis for a Fair Credit Reporting Act claim. There have been a few other positive decisions dismissing this kind of idea of a legal versus a factual dispute. In Holland, a case cited here, the plaintiff brought a Fair Credit Reporting Act that was based on the running of the statute of limitations, which the court dismissed because, again, that is more of a legal inquiry that reviewers cannot determine versus a factual one that may be found in a creditor's and a furnisher's files. Similarly, the plaintiff in Gross asserted a FCRA claim based on the uncollectability of a debt due to Arizona's anti-deficiency statute. The court dismissed again on a motion to dismiss stage plaintiff's claim, finding that the defendant was not obligated to conduct a legal investigation into the collectability of a debt. Now, I think these cases, one, they're important to note, make sure you're aware of, because if you haven't been sued with this kind of silly theory, you probably will be. And these cases are very recent within the past few months and present a really good roadmap for the dismissal of these claims early on. And we all know by dealing with this, the Fair Credit Reporting Act litigation, the dismissal of claims at the outset are really difficult to do. So these are some good cases that can provide a framework for that. I also think these cases bode really well for kind of the backbone for potential CARES Act defenses. Arguably, whether an account is subject to an accommodation and should be reported as current under the CARES Act, I think one could argue that that too is a legal determination. How could your rep, looking at a file, determine if an account is appropriate and needs to be reported as current pursuant to the CARES Act? If that's what the basis of the claim is, I think there's a pretty good argument that that is a legal determination and therefore not an actionable FCRA claim. So I think that bodes pretty well for potential arguments in the future. Prabir, anything on that?
Now, yeah, again, a challenge that the industry faces, the charge-off function internally is always something, that's really your operations unit, your servicing unit, and sort of making sure that you have that coordinated with your credit reporting is a challenge. And yeah. But I like Ryan, I like where you're going with that as a potential defense. That's a great point.
So if we could back up one slide, I kind of skipped ahead. So the last thing I want to talk about quickly, and we're starting to run out of time. I mean, we could talk about, Prabir and I could talk about this for an hour, so a half hour is very difficult. But I do just want to hit a couple quick highlights on something else that I think clients continue to struggle with, which are claims of identity theft, claims of fraudulent accounts. These disputes lead to some of the most significant exposure for furnishers, and they're becoming, frankly, just more increasingly difficult to resolve. First, I think plaintiffs' counsel are doing a much better job of vetting and identifying those cases where there are true identity theft. And what used to be kind of low to medium dollar figure settlements have increased significantly. These cases also lend themselves to kind of bad facts, which can subject furnishers to potential punitive damages. As a result, I just want to offer a few observations regarding potential improvements and shortfalls in review policies and procedures for these specific disputes that I've seen. The first is that it's important to review not just the dispute codes, but also the attachments to any of the disputes that are submitted for potential claims of fraud. I've seen an increase in cases where there are just these generic dispute codes, such as general inaccuracies or an 01 code, which is an account not his or hers. But the attachment may have a claim or a statement of true identity theft somewhere in the narrative. And these cases these disputes are being missed and not routed through proper fraud procedures. maybe I've been a defense attorney too long, but part of me believes that this is perhaps intentional. And it reminds me of those communications where consumers were burying TCPA revocations in the text of a 2-page letter or a 5-minute communication with a representative. So you're gonna wanna make sure that your policies and procedures address that. And then the next point, which I still think bears repeating, is it is unreasonable on a claim of fraud to review a database and simply confirm a customer's personal information matches the individual's information making the dispute. I say the reps have to go, quote, beyond the screen and conduct a more thorough review. This should include a review of call records, account histories, address and contact histories, and origination files if you have them. And the decision listed below kind of highlights the struggle companies face, because questions of reasonableness of an investigation are almost always a jury question, which relates in more legal fees and more potential exposure to companies. Next, companies should ensure that reviewers have access to documents across departments and to archive documents. This is essential. I've dealt with a number of cases where reviewers cannot review any ongoing or prior fraud investigations because they're in another department. This is a mistake. This will create those kind of bad facts that are the cases that become very, very difficult to resolve and create a lot of potential exposure. I've also had a case recently where a reviewer missed an essential indicia of fraud because a portion of the account history had been archived and couldn't be accessed. That's another example of just to make sure that the policies and procedures, including any document retention policies and procedures, are being thought through, particularly in the area of fraud disputes. Finally, we discussed furnishers should consider looking to obtain information from other sources where their files are insufficient or incomplete in some regard. But I think for most folks, this is not going to necessarily be an issue, but you should look for disputes where maybe you don't have specific information on a specific issue, and maybe you do need to go back to a third party. It's just something for us who counsel the industry to kind of think about now a little bit more. Prabir, I think we're up against it. Anything else that you'd like to add before we pass it along?
Now that policy, I read that the decision, and the interesting thing for me was the initial complaint was that it was somebody I think in the household was that their information was being reported on the plaintiff's credit. And I mean, those are things, again, interplay between the credit reporting agencies and something that you've got to investigate. Is your obligation.
Great. Thank you so much, Prabir. I really appreciate the time today. It was great.
Thanks a lot, Ryan.
So now I'm very excited to present our next presenters who are going to give us a TCPA update and take a close look at the Facebook case that's currently pending before the Supreme Court. First, I'm thrilled to introduce Zach Miller, who is a partner at Burr Foreman and is located in Nashville, Tennessee. You'll note Zach is the only outside counsel outside of Saul Ewing that was asked to speak here today. Zach and I have a few mutual clients, and I can tell you that Zach is an exceptional financial services lawyer and is a TCPA expert, which is why we asked him, and we're thrilled to have him here today.
Thank you, Ryan.
Colleen is a terrific consumer financial services litigation attorney here at Saul Ewing, Arnstein and Lair. Colleen is currently on maternity leave after having a beautiful baby girl, but has graciously agreed to join us today. Colleen is our resident TCPA expert, and I can say firsthand, an absolute essential member of our team and someone who I am missing quite a bit these days. So thrilled to have you guys, Zach and Colleen. Take it away.
Thanks, Ryan, and good morning, everyone. So as many of you have probably seen, the TCPA has been a hot button issue with the Supreme Court lately. It's back before the court for the second time just this year. So Zach and I will focus our presentation on Facebook versus Duguid, which promises to resolve the current circuit split on the, as we all know, very frequently litigated issue of what constitutes an ATDS or auto dialer under the TCPA. It's a really timely issue because the court just heard argument on Facebook last week. We expect there'll be a decision sometime in the spring of 2021. And we expect, depending on the scope of that decision, that it's either going to potentially stem the tide of TCPA litigation or expand it. The silver lining, no matter what the result is that there will finally be one uniform standard of what an ATDS is across all circuits and jurisdictions for compliance purposes. If we could go to the next slide, please. So just an overview of where we're heading today. We're going to start with a quick review of the definition of an ATDS under the TCPA and how various circuit courts and courts throughout the country have interpreted that definition over the years. We'll take a look after that at the judge's pre-Ducat statements on the TCPA and their comments from oral argument last week to see if we can glean from that where the court is potentially heading in a decision. And then we'll close out. Zach's going to address the application of the TCPA to some newer technologies that are being used in our industry. Next slide. So under the TCPA, an ATDS is defined as equipment that has the capacity to store or produce phone numbers to be called using a random or sequential number generator and to dial those numbers. The definition, as you can see, is somewhat awkwardly worded, and therein lies the problem. Over the years, the issue that courts have grappled with is, does a device need to randomly or sequentially generate numbers that it calls in order to be an ATDS, or is it sufficient that a device just dials numbers from a list? Next slide. So we've identified kind of 4 statutory interpretations that have been advanced by courts throughout the country. The 3rd, 7th, and 11th Circuit have adopted a narrower definition and have held that the phrase using a random or sequential number generator modifies the words store and produce, which means in their view that a device needs to be able to either store or produce numbers using a random or sequential number generator and to dial those numbers in order to constitute an ATDS. On the other hand, the 2nd, 6th, and 9th Circuit, including the 9th Circuit in Ducat, which is currently on appeal, have adopted a broader definition and have held that the phrase limits or modifies rather the term produce. So the definition in those circuits captures devices that can produce numbers randomly or sequentially and devices that can just dial and store numbers. Other interpretations that have been advanced are that the definition captures only equipment that dials randomly or sequentially generated numbers, or finally, that the phrase using a random or sequential number generator describes the phone numbers to be called regardless of how they're stored, produced, or generated. Next slide.
All right, so, it's not lost on us how incredibly boring some of this discussion is. And if you listen to the Supreme Court arguments, what you hear is this battle between the justices, and that they want to essentially take some of this statutory construction, this real grammar nerd stuff, and throw it aside. But it's difficult to do it because this is the language of the statute. And this difficult ATDS definition is something that we've been dealing with since 1991 and really since 2003, when the FCC decided that they were going to take steps to expand it in a way. And so when we're digging into these, different interpretations of ATDS, what is the goal? What do we really care about? What we care about is the impact on predictive dialers, because for folks in our industry, and Ryan and I primarily represent folks in the consumer finance industry. We're talking about using predictive dialers to reach lists of customers who are delinquent, who are behind. And those predictive dialers were started to be created in the late 80s using modern computer technology to predict when someone may answer the phone. So, you know, if only 10% of the time someone answers a call, and now actually it's less than that, it's closer to 5, then do you make 20 calls in the hopes that one will be answered to make it more efficient for you to use employees and actual real life people to contact these individuals? So it's the use of predictive dialers that we care about. And like I said, starting in 2003, the FCC said, despite this random or sequential language in the definition of ATDS, we are going to expand our reading of the statute to include predictive dialers. And they have consistently, I mean, you have to give credit to the FCC, and that even through different administrations, the George W. Bush administration in the early 2000s, and then the Obama administration, they've kind of consistently held the same opinion, which is that predictive dialers are included, despite the fact that you have to have a strained reading of the statute to get there. So in 2015, the FCC definitively stated again that predictive dialers are an ATDS, but then in 2018, the DC Circuit invalidated that opinion. So the next slide has a map that shows kind of where we stand today. If you're looking at bright red, those are circuits, or states within federal circuits that have advocated this Marks approach from the Ninth Circuit, that there's going to be a broad interpretation of the statute, and that's what they've held. Bright green, the opposite. Federal circuit courts that have a narrow interpretation of the statute. The first one, as Colleen mentions in those 4 possible interpretations from the Gattelhack opinion. If we have like a minty green kind of color, that's, you have a district court within that state that has advocated, or multiple, a narrow interpretation, and that all prior FCC orders on this issue have essentially been overruled. And Rhode Island stands alone right now, is with the district court that have held that there is a broad interpretation of the statute. So that's where we stand. This is a true circuit split. It's 3-3 when the Supreme Court took it up. And that's when, as Colleen will discuss, all of our dear friends, Sergey Lemberg, decided to take the dumbest possible case to the Supreme Court.
So Duguid's path to the Supreme Court began about 3 years ago in 2017. The plaintiff, Noah Duguid, sued Facebook, alleging that over the course of about 10 months, he received unsolicited text messages from Facebook, letting him know that somebody had tried to log into his non-existent Facebook account. Mr. Duguid filed a lawsuit in the Northern District of California. He very generally alleged, really without any specifics, that Facebook had sent him texts using a predictive dialer-like system. Next slide. Facebook moved to dismiss, which the district court granted. The district court agreed with Facebook that the plaintiff didn't sufficiently allege that an ATDS had been used to contact him, because his complaint didn't contain any allegations that texts were sent by Facebook in bulk using a random or sequential number generator. Duguid appealed, and the Ninth Circuit reversed. It adopted that broader definition of an ATDS, which is currently on appeal now at the Supreme Court. The court said it's enough that a device can store numbers to be called and dial those numbers automatically in order to be an ATDS. The court concluded that an ATDS had been used in that case because Facebook, one, maintains a database of phone numbers, programs its equipment to automatically generate messages to those stored numbers, and automates even the aspects of the messages that appeared to be personalized. The Ninth Circuit then reversed and sent the case back to the district court. Next slide. So the Supreme Court agreed to review Duguid just this past summer. The sole issue that's up on appeal with the Supreme Court is whether the definition of an ATDS includes any device that can store and automatically dial phone numbers, even if the device does not use a random or sequential number generator. If the court ultimately does adopt the narrower version of the ATDS that we've seen adopted in some circuits, and its decision is drafted in a way that encompasses predictive dialers, we could potentially see these claims start to dry up in a significant way. The flip side of that is that Facebook didn't use a predictive dialer. This case was decided on a motion to dismiss, so there's no discovery into the type of system that was used. And if the court issues a narrower ruling this coming spring, it's not totally clear how that's going to apply to predictive dialers or to our industry.
So, you know, we can move to the next slide, but just quickly on Do Good and my pot shot at Sergey Lemberg. I mean, you know, Ryan just spent time talking about the Fair Credit Reporting Act and Probir. They did an incredible job. They know the ins and outs of it, every single status code you could put on things, how judges in different areas have interpreted that. For others of us that have focused on the TCPA for like the past 12 years, you know, I'm not ashamed to admit that unlike some bloggers, like I'm not really a huge fan of this statute just disappearing that, you know, I've read every single opinion on for the last 12 years. And so while it would be great for, you know, a lot of Ryan and I's shared clients, you know, not something I'm particularly personally stoked about. That's why there's like a little frustration with Sergey Lemberg in that you've had this money-making machine for the last 10 years, which is that these companies that really under the definition of the statute shouldn't be subject to the TCPA, you know, folks using predictive dialers, are being sued and there are large judgments against them and things are going well for plaintiffs' attorneys. And so you have to go and sue Facebook for what generally would be understood to be like messages that are appreciated by people, right? Like an unauthorized access text message warning you of somebody entering your account. Why you would bring that claim is beyond me. And now that case stands before the Supreme Court. And so we're not talking about predictive dialers, which generally I think the justices would be, more of them would be predisposed to have an opinion against the use of predictive dialers for debt collection. We're talking about texts that people actually want. And so, you know, what we saw in the argument is that, you know, a lot of that consumer versus industry like dynamic that for years has been supporting a broad interpretation of the TCPA was gone. And it wasn't contained in those arguments because this is like messages that people actually want. Sure, Facebook engenders bad feelings in other ways, but not for account security. So we get to, okay, what are these justices? What may they do? Because really what is at issue is the statute itself. I mean, if there is a narrow interpretation of the statute, we are going to see TCPA claims against servicers and debt collectors and creditors disappear, which is fantastic for the industry. It's bad for me. I'm gonna have to come work for Ryan and Colleen and do Fair Credit Reporting Act stuff all the time. But it's good for you guys. And so what are the chances? The chances are good. The chances are good that there would be a narrow interpretation. And if you would have asked me a year ago when Barr was in front of the Supreme Court, I would have told you I didn't think that the Supreme Court was going to find the entire statute was unconstitutional. I feel much differently about this. So let's examine the prior statements before the oral argument from these justices. So the next slide. First, you have what I think is probably the most important, which is Judge Kavanaugh. So in the Barr opinion from July of 2020, when the Supreme Court held that the statute was unconstitutional when it came to the government debt exception, just a small little portion of the statute, but that portion was unconstitutional, the rest of the statute could survive. Now we've had some decisions after that. State calls made while there was an unconstitutional provision in the statute may not actually count. Those, you know, the statute may have been unconstitutional for that whole provision. That's another discussion though. What does Kavanaugh say about the TCPA that may, you know, show us how he's going to rule in Do Good? He has a strong pro-consumer take. He says, you know, Americans passionately disagree about many things, but they hate robocalls. He says for 30 years, the people's representatives in Congress have been fighting back against robocalls through use of the TCPA. Now, what does he do here that I don't like? He uses the word robocalls, which isn't contained in the statute at all. Typically, robocalls are understood to mean pre-recorded voice or automated messages, which, you know, really the main concern in the TCPA when we're talking about interpretation is the definition of ATDS. And I don't think an ATDS call constitutes a robocall. Maybe that bodes well in the do good decision for a limited, if you're looking to see a limited scope of Kavanaugh's statement here, but it's unquestionable that Kavanaugh believes, perhaps incorrectly, that the TCPA is battling these unwanted calls. I think that he's getting a little confused that, the random messages that we all get on our phones, if you don't owe a bunch of money to creditors or debt collectors, those are legitimately random or sequentially dialed calls. They're just spam, they're spoofing, they're scams offshore. People trying to place calls to American cell phones to try to get them to, give up their personal information, say it's the Social Security Administration, car warranty or whatever. The TCPA doesn't do anything to protect against those types of calls because you can't find those people. I can't sue the folks that, call my cell phone with spoofing technology because they're not located in the United States and, they don't have any assets. But if we're talking about, calls, that are actually from creditors or debt collectors, those are the calls that the TCPA is actually having an impact on. And I don't think that's what Kavanaugh's talking here, but you see a pro-consumer stance from him. Next slide. Justice Breyer, I think pretty clear that he has a pro-consumer position here. His statements here in the Barr case aren't really helpful to finding out how he's going to rule in the do good decision. But there's nothing he said in the Barr case or in the oral arguments that makes you think that he's going to advocate a narrow interpretation of the statute. So the next slide leads to Gorsuch. And I would say the opposite for Gorsuch. It is very clear that he is going to be in favor, I think, of a narrow interpretation of the statute, just like you would suspect he would be. He's essentially said what the industry has advocated, which is that the TCPA, which was created in 1991, did its job. It was successful. It eliminated random or sequentially dialed calls. So you're sitting at home, your phone rings, it's someone trying to sell you a vacuum or whatever. It's a legitimate American company with assets trying to sell you some product or service, and it just has dialed your number randomly. It's eliminated those calls. And those don't really happen anymore. It's done its job. And Gorsuch and Thomas would say, let's not take this statute and reimagine it and reinterpret it to comply with, to have an impact on today's technologies. All right, next slide. Another very easy one. So Justice Barrett, she already wrote the decision in Gattlehack in the Seventh Circuit. She has been clear. You can go read her opinion on how this, comes down. She said specifically she would advocate a narrow reading of the statute, that the words using a random or sequential number generator applies both to store and produce. So you have to have, one or the other. It's not just storing numbers and dialing them automatically. So it is clear that you can put her in the realm of a narrow interpretation. So the next slide. So pre-oral argument, this is how Colleen and I think these justices come down. You have three on the right that would have pro-industry interpretation, I think, for sure, Thomas, Gorsuch, and Barrett. You have Kavanaugh, who surprisingly is probably leaning toward a more broad definition, and then Breyer on the far left as well.
Okay, if we take a look at the next slide. So as I mentioned, argument took place just last week. Basically, it's an hour-and-a-half debate on hyper-technical grammar rules and syntax. Zach and I took one for the team and listened to it, so you don't have to. Facebook is basically advocating the position that's been taken by the 3rd, 7th, and 11th Circuit, that using a random or sequential number generator modifies the phrase or the words produce and store. Interestingly, the Department of Justice intervened on behalf of Facebook. It'll be interesting to see whether that sways the court's decision at all. The DOJ split up the argument with Facebook's attorney, Paul Clement. The plaintiff also focused on grammar and syntax, but he argued too that the plain meaning of the ATDS definition in the TCPA should be read to include devices that store and dial numbers to be called by a list, because in his view, any other reading would undermine the entire purpose of the TCPA. So Zach's already addressed the other justices' statements who have commented previously on the TCPA. We're going to highlight Roberts, Kagan, Sotomayor, and Alito's comments during oral argument last week to see if we can get a better sense of where the court's heading. Next slide. So Justice Roberts wasn't super interested in the hyper-technical grammar arguments that Facebook was making. I'd say that was kind of a general theme among all of the justices. He asked Facebook's attorney that when Congress drafted the TCPA, it wasn't diagramming sentences or focusing on syntax. So why should the court do that now? In his view, the best way to interpret what an ATDS is under the TCPA is just ask how an ordinary person reading the statute would interpret it. With that said, he told Facebook's attorney that its narrower reading of the ATDS definition rather made the most sense to him at first blush, so it seems that he's leaning that way. Next slide. Justice Sotomayor also seemed to favor Facebook's definition, but she said several times, as did several of the other justices, that the TCPA is basically outdated and archaic and Congress needs to update it at this point. She was worried, though, that if the court adopted Mr. Duguid's reading, that an ATDS would include cell phones because they can store and dial numbers. She suggested that result would be absurd and disastrous, understandably, because then every cell phone owner would be subject to the harsh criminal and civil penalties of the TCPA. She asked Duguid's attorney to give her a reason, other than that it hasn't happened yet, for why the court would have intended that result. It looks like that unintended consequence of a broader reading is definitely a concern for Justice Sotomayor. Several other justices raised it as well. So that's definitely going to be a concern for the court as it attempts to identify what the definition is meant to be under the statute. Next slide. Justice Kagan was one of what we think is a minority that favors the broader definition of an ATDS. She noted that when the TCPA was enacted, there were a lot of state statutes that addressed basically the same thing. And those statutes didn't define an ATDS to include a random or sequential number generator. She asked the DOJ's attorney if that suggested that its definition, the narrower definition advanced by both the DOJ and by Facebook, was wrong. Like Justice Roberts, she was way less interested in syntax and said the court really should just be applying the ordinary meaning of the statute, which she seems to think favors of the plaintiff. Next slide. Lastly, Justice Alito, he was one of the most vocal about the statute being outdated. Interestingly, he said that if a court had the power to declare a statute obsolete, the TCPA would almost definitely be a good candidate for that. He was also skeptical, though, on the other hand, of the definition advanced by Facebook. He said, again, the court shouldn't focus on grammar treatises, but really on what makes sense when an ordinary person looks at the statute. To Mr. Clement, he asked, does it make any sense to speak about storing a list of telephone numbers using a random or sequential number generator? If the answer to that is no, he thinks that Facebook's definition has a real problem, and he seems, based on that, disinclined to adopt the narrower reading. And on the next slide, Zach's going to address where we think the justices are post-oral argument.
So, with the understanding that there was a lot of playing devil's advocate and, that Supreme Court oral arguments are never clear and there's keeping your cards close to your vest, this is where we think, just based upon their prior statements, plus the statements during oral argument, plus understanding their political leanings and how they are when it comes to the textualist approach, these justices would land. And so I think clearly right now you would have to expect that there would be a ruling that there's a more restrictive definition of ATDS. And if that happens, what does that mean? You know, I think that it opens the door for a broader use of predictive dialers. You know, traditional notions of consent may have to be reconsidered. And, you know, I think that servicing departments and operations managers are going to be very excited regarding this development. And so that's where I think we lean now. But you know, kind of with other decisions, Kavanaugh and Roberts now are in the middle. And so we're looking to see, you know, how those two decide. And, you know, in my opinion, I think it's probably 75-25 or, you know, 60-40 that you're going to see a more restrictive definition, a narrow definition of ATDS. So during the advertising of this presentation, we said we'd also discuss new technologies. Well, this oral argument just kind of ended up being so much more important than that. But I just wanted to highlight that texting is changing. How texts are sent is actually changing. A lot of folks on this call, you may work for a company or may represent a company that has used short codes or shared short codes previously to conduct debt collection or marketing. Those are disappearing. Folks won't be able to share short codes anymore, which is like kind of the industry, you know, the best thing you could have in the industry is a short code to send out your texts. Shared short codes are disappearing. The industry is transferring to 10 DLC texting, which is when you send a text, actually a 10-digit number appears. And they've figured out a way to make that happen more quickly so you can send text to more individuals. So it's worth just noting that. And if anybody is really interested in this hyper-technical stuff, please reach out to me. But that's it. I want to stay on time, give everybody a chance for a break. I want to say thank you to Colleen and thank you to Ryan very much for allowing me to present. And hopefully I'm not working for Saul, just doing mostly credit reporting stuff after the Supreme Court ruling comes down, but I don't know.
Thank you guys. That was terrific. I mean, a lot of people are talking about that Facebook case, but honestly, that was one of the best assessments of the potential outcomes I've heard to date. So thank you guys both. That was really awesome.
Thank you.
We're going to go ahead and take what is about an 8-minute break. So we'll reconvene at 10:30. So go ahead and stretch your legs, refill your coffee, and we'll come back at 10:30. Okay, welcome back, everybody. I am thrilled to introduce our next panel, which is our litigation roundtable. And I'd like to start by introducing our panelists. First, we're joined by Jason Bishel. Jason is corporate counsel at BMW Financial Services in Columbus, Ohio. He's responsible for managing BMW FS's consumer litigation in the southern and western regions, and also supports a number of operational departments, including topics on collections, credit reporting, lease maturity and early termination, including FCRA, marketing, mobility services, privacy, and vendor management. So Jason, thanks so much for joining us. Next, we have Justin Bradley. Justin is the Associate General Counsel at New Res and Shellpoint Mortgage Servicing. Justin oversees a 20-person litigation team and manages litigation arising from both the mortgage and the origination services businesses. And last, but certainly not least, we have Mike Galliano. Mike is the Senior Director and Managing Counsel for Alliance Data Card Services and Community Bank. Mike serves as the head of the litigation department and manages the company's portfolio of litigation across the country. I've worked with Mike for a number of years now, and he has some really interesting and unique approaches to managing outside counsel that I hope he'll share with us and we'll get into today. So with that, I'm gonna very, very briefly, because no one wants to really hear from me on this panel, just go over some litigation trending that we're seeing. According to WebRecon, FDCPA claims are down more than 15% this year. This is not altogether that surprising because collection activity has been slowed. I don't expect this trend to continue once companies begin to ramp back up their collection efforts at some point next year. TCPA class cases remain somewhat flat. This isn't entirely consistent with what I've seen internally. We've seen more of a regression of these cases in the past few years, and depending on how the Supreme Court rules in the Facebook case, that regression may continue. We've also previously discussed Fair Credit Reporting Act trending, which I'm not going to go over again. So that's enough for me. Justin, can you lead us off and talk about some of the litigation trends your company has seen this year? Justin, I think you're on mute.
All right, sorry about that. Yeah, thanks for having me. And in terms of our litigation trends, typically what we see on the mortgage side is a high concentration of cases that are filed that I would call the wrongful foreclosure type cases. Those cases, particularly in California, Texas, states that are non-judicial, and so the only way for a homeowner to challenge the foreclosure process is by filing those separate actions. And that typically has been about a third of our litigation across the country, and this year it's practically non-existent. We saw it right at the beginning of the year, and then just completely drop off a cliff when the foreclosure moratoriums went into effect. So for us, certainly we're planning, what does that mean for us next year as those moratoriums lift? But for the time being, it certainly has depressed a lot of litigation activity that we've seen. We have seen a little bit around FCRA, TCPA, but again, a lot of those categories are really down as we're not seeing that traditional debt collection activity occurring.
Well, that's great. Thanks, Justin. Mike, how about you from Community Bank's perspective?
I think our stats match nationwide, but probably even more consistent with yours. We have seen a FCRA has gone way up, FDCPA gone way down, but the TCPA and the state collections have also gone down. According to this, 30% each. And while total litigation has only gone down 20%, TCPA has gone down 30%, so it's outperforming.
And Jason, from BMW's perspective, are you seeing anything different than the group?
I don't think so. Litigation hasn't really upticked too much for us, but we started to see the pre-litigation machinations start to increase a bit. Also seeing an increase in California Small Claims Act litigation, or California Small Claims litigation, where it's a little bit challenging for us because you're not allowed to send a lawyer to represent you in California in small claims court, and when the rules vary in terms of whether a court's allowing you to appear telephonically or requiring people to show up in person. When you're trying to protect your employees, during the pandemic, that can be a challenge. Also seeing a little bit of an uptick on bankruptcy fraudulent transfer cases.
Just staying with you, Jason, what are you anticipating for 2021? Have you started, I'm assuming, planning already, and what are you kind of anticipating from a litigation perspective?
I mean, I think the Fair Credit Reporting Act is going to be the primary focus for us, with the CARES Act and the challenges that presents. We're just waiting for those cases to start rolling in. Haven't seen any CARES Act cases yet, but I fully expect them. And in addition to that, just any allegations that the company's COVID-19 relief was insufficient or otherwise created a UDAP problem, something like that. I mean, we see those sorts of arguments in wrongful repossession cases and things like that generally. So I expect that'll become the COVID focus will become part of those cases next year. And like I said, I also expect the bankruptcy litigation to increase. So far, I think that the relief provided by Congress and the states has kept consumers generally out of bankruptcy so far. I have to imagine that unless significant action is taken, that those cases will start to show up. And so some of our litigation is going to be in bankruptcy court.
And Justin, how about you guys? Can you comment on 2021, kind of what your company is planning for?
Yeah, I mean, we're certainly anticipating an increase in litigation as those foreclosure moratoriums come off. For us, about 60% of our portfolio was covered by CARES Act. And so we have private lenders that are really driving the programs for those other 40% of our portfolio. And so while we're offering, a lot of relief, and they're being very generous with what they're able to offer and trying to mirror CARES where they can, certainly those moratoriums are going to come off at different times. And so for us, it's really a question of timing when those happen, and there will probably be some tail on that. We're certainly not going to resume foreclosures day one immediately as soon as those moratoriums lift. There's still going to be a lot of loss mitigation work that's going to be happening to try to avoid that from occurring. So for us, it's really a question about timing, but we're still anticipating somewhere around a 30% increase in litigation based around that. We have seen a couple of CARES Act cases to date, and without going into a lot of the details, the two areas that we've seen are, of course, FCRA related, and primarily that has been on our non-CARES portfolio. And then the other claims that we've seen are these wrongful foreclosure type claims, arguing that the relief that was offered wasn't sufficient, and trying to challenge the foreclosure. In all of those instances, I think the kind of unique factor has been those all involve vacant properties and delinquencies that long predated COVID pandemic circumstances. So these are borrowers that were delinquent for some time period long before the moratoriums came into place. So I suspect we'll continue to see some of those cases over the next few months, but really waiting for those moratoriums to lift to see what happens.
Yeah, that's great. Thanks, Justin. Mike, how about you guys? 2021 planning. What are your expectations?
So I'll share the observations that Jason had about CARES, and that's more similar to our type of practice than Justin's. But one thing I'll comment on that maybe others haven't is on the TCPA. Obviously, so presuming the decision comes out in mid-spring, if it doesn't go our way, then I expect a barrage of TCPA cases. If it does go our way, what I expect is going to happen is that Congress the next morning will, I'm sure they will already have it drafted, but it's one of the few things might come out of a Supreme Court that would actually be on the morning shows. And to pick up on Zach's point, with the concern I always have is the term robocall, and they will call it. The Supreme Court has now legalized robocalls. The world's going to end. And one pandemic's been replaced by another. And the legislation that's been sitting in Congress the last 2 years on privacy, they've gotten pretty close on this issue. And even if you presume that two Democrats in Georgia win, and even given the fact that the Republicans now are only within 6 flip Democrats to stop something in the House, this is the type of thing that could flip 2 or 3 Republicans easily in the Senate, and the same in the House. And what stopped privacy legislation so far has been the issues of preemption, and they may split those off and just have an anti-robocall bill. And Republicans who look to be reelected 2 years from now are going to have a hard time voting against that and trying to get into these discussions that nobody wants to listen to. So I'm worried that even if we win robocall, we don't win robocall. Or TCPA, I should say. See, I'm even using it myself. It's bad.
That's a really interesting observation, and Zach will be thrilled to hear that he's still going to remain employed either way, even after, regardless of which way this goes. So I'm sure he'll be happy to hear that. Mike, let's stay with you and just talk about the challenges some of your department has faced this year. Going to what is, I know, is a fully remote environment, and how you've kind of dealt with those challenges.
Well, first, I think they're all listening in on this. So, and not just because of that, I'm going to give them a shout out because it is a great team. And you've had the benefit of working with them, you and Colleen and Zach as well. So you know what I'm talking about. But it has been challenging. We have a small group on this team, about 6 or 7 people. And we all sort of I'm sitting there now, but it's an empty hall. It's an empty building besides me. And we have our weekly meetings and we stay on top of things, and it's very cohesive. So everybody at home is still very productive. But yeah, I guess I would say we work just as well, but we're not having as much fun, in my opinion. Maybe they think it's more fun to have less involvement with me, but I'd like to think not. The challenge, I think, will be as time passes and you onboard people to get them up on the things we do, because as you know, we do some things maybe other departments don't do, and that sort of hands-on training might be a little more difficult remote, but I'm sure we'll meet the challenge.
Hey, Jason, how about you? How's this kind of affected your department? Any challenges you guys have faced?
Yeah, in many ways, the challenges I think we share with every other department in our entire organization and with all of you. It's just working from home with your kids at home and you're where you're kind of separated. I'd echo what Mike said. I miss interacting every day with my colleagues, right? And I'm not just saying that for the couple of them that are on the call. But from a legal department specific perspective, it's a mixed bag. I think one of the things as in-house counsel that you really value are the drop-in conversations where you tend to, somebody passes by your office and they want to pop in and talk to you, and you encourage that because that's where you learn things about your organization that you probably weren't going to learn in a larger, more formal setting. And the number of times we've been able to find something out that way and then fix it before it becomes a larger problem is pretty significant. Now I think people, at least in my experience, have been less likely to just pick up the phone and call and interrupt you. They think they're interrupting you. So they want to set up a meeting at a designated time. And if they're going to set up a meeting, then they want to feel like it's important enough to do that. So you lose some of that. On the flip side, not having a lot of the distractions necessarily every 5-10 minutes during the day, I've gotten a lot of my larger project work done that maybe I wouldn't have gotten done had we not been at home. So there have definitely been some advantages to that. And so going forward, my hope is that we can have a mixture of being in the office and working from home, and we can learn from this experience that this works.
Yeah, that's interesting. And that's kind of, Justin, I mean, I'm interested in your thoughts on that too, which is not just what you guys have been through, because I think it's going to echo largely, but is this going to change things for your department, Justin, in terms of how people will work remotely and what you guys as a company may be willing to kind of set up for folks?
Yes, it's definitely been interesting. We have, for us as a company, moved, 97% of our staff company-wide to remote, and really did that in the span of just a couple of weeks. And being able to transition the entire legal team remote, it wasn't that big of an uphill battle for us, because we tend to operate a team that's very already technologically adapt and paperless and utilizing those kind of opportunities with our mailroom and things like that. So, from the legal team's perspective, it was pretty easy, and I hope it's going to be continue to be a benefit for our team and something that is beneficial to do long term. I echo what Jason said. It certainly is. There are those times that you miss those opportunities of being in the office and being able to speak to others and just pop in and casually come across an issue while you're speaking with someone in the hallway. But that just means we have to be more intentional about those times, and certainly more intentional with our team. Like Mike, I miss those times of just being able to stop by my team's desk as we walk by. And I think it's going to be tough bringing on new people without having that ability just to poke your head up and ask a quick question. You got to be more intentional about that across the board. But I'm excited about it. I think it certainly opens up some more opportunities for us to be able to bring in staff that isn't focused just on our couple of geographies. We have 3 main servicing offices in South Carolina, Texas, and Arizona, and then we have some origination offices throughout the country. But being able to not just be fixed by those office locations and looking at bringing on staff across the country certainly opens up more opportunities for us.
Yeah, I mean, that's the one thing that I think is really interesting is, to see the long-term effects this has on the way in-house counsel operate in terms of the geography piece of it. I mean, our company is going to be, and department's going to be more willing to say, it's okay, you're located in Florida, even though we have operations in Ohio. You know, and, you know, Mike, would that be something that you guys, you know, would do going forward, seeing how this is kind of progressed this year, or you still think that that in-person touch is really important and you want your team there?
Kind of putting me on the spot now, Ryan.
You don't need a definitive, just thoughts on it.
I, of course, would like to see everybody once it's safe for everybody to be seen in person, but sounds like our company is like others, which is even once this runs its course, we're never going to go back to 100% in the office. There will be a material number, and I don't want to state some public policy that isn't public yet, but it will be significant, the number of people that are working from home. And then that brings up the issue of, do you need those people, if they're working from home, to at least be somewhere near an office? And that's something we're going to have to work through. So,
hey, Jason, how about you?
I guess we'll deal with it.
Do you have any thoughts on whether or not it would change things from a recruiting perspective, or what you guys as a company may be willing to do?
You know, Ryan, I don't know. I think we haven't thought that far ahead, to be honest with you.
That's fair. Justin, this next one's for you. I mean, this isn't specifically COVID related, but you know, over the past few years, I certainly have seen more pressure as outside counsel to kind of deal with alternative fees for the management of litigation, particularly litigation that may be of a lower dollar value and more repetitive. Can you talk to us a little bit about how ShellPoint and New Res are using alternative fee structures?
Yeah, absolutely. So, you know, for us, I mentioned already, you know, one category of our litigation that is very, you know, similar, right? Those wrongful foreclosure cases are a category of litigation that we see very frequently, very similar fact patterns, very similar allegations. And so for us, you know, we've had a number of those categories of litigation that we've looked at and said, this is an opportunity for us to try to have more predictable litigation costs, more predictable spend, and for us to explore some alternative fee arrangements. And I understand, you know, some of the concerns about that, both from the in-house side and from the outside counsel perspective. At the end of the day, you have to have these arrangements in a way that is beneficial to both parties. You want to make sure you understand what the incentive structures are when you're adopting these kind of arrangements and being able to implement them. So we've been you know, testing over the last 18 months or more a number of options. You know, for those wrongful foreclosure cases I mentioned, you know, for us, that's an opportunity for us to look at incentivizing our team to try to resolve those cases earlier. Most of those cases resolve through some form of loss mitigation. And for us, being able to get that loss mitigation completed earlier in the process is beneficial to everyone. And so we actually implemented for that portfolio of cases, working with our third-party clients that we're servicing for, effectively a flat fee per month, almost a monthly retainer for those cases. And understanding that the incentive there, not that we have any outside counsel partners that would try to drag out those cases in order just to bill a higher amount, but understanding that the life of those cases means the longer the case goes on, the more expensive it's going to be, incentivizes us to try to work through our process and review them for loss mitigation at a much earlier perspective and try to resolve it that way. So for us, we've seen at least a 10% reduction in litigation costs on that portfolio of loans. We've also implemented a number of other arrangements for different categories of cases, everything from traditional fixed fee per life of case up through a certain stage to what we've been experimenting with, which is a capped fee. So basically it's a capped budget through a certain milestone in the case, typically through motion for summary judgment, where we agree with the firms that it's going to be a certain dollar figure up to that point as the cap on the budget. Certainly there may be savings there, and we may share some of those savings with the firm to incentivize all of us to come in lower than what the budget is. But that's an interesting model that we've been experimenting with. And then the other, more traditional kind of arrangement is just negotiating those hourly fees. There's going to be cases that we have to litigate, and for volumes of cases, looking at how can we have more predictable spend across the country, across different jurisdictions with some of our more national counsel. So for us, certainly this is a year where budgets mattered probably more than any other year I've been doing this. And we've been happy that with implementing those, certainly pre-COVID, this was not a direct effect of COVID, but we've been able to see this year alone about a third reduction in our average litigation costs with these different arrangements. So that certainly has been a positive model for us. And I think as we go forward next year, we're going to be looking at ways to both expand this and kind of double down on what's working there.
And do you have, when you have the kind of capped fee structure, do you have any release valves or release mechanisms that allow firms to kind of deal with the one-offs, right? To deal with the one-off large cases?
Yeah, we thought a lot about that and discussed it a lot with the firms. And what we came up with is the idea that, look, we don't want to have an exemption that is so broad that effectively every case ends up falling outside of that. Likewise, we don't want to have such a rigid process where the firm is losing money on every case because we priced it incorrectly. And so for us, we came up with a model that allows 10% of the cases to be exempted from that model. And we really put the onus on the outside counsel to tell us which cases they think those are based on their projections and initial discussions with opposing counsel, different fact patterns they're looking at. So, when they're bringing us the budget, we're putting the requirement on them to tell us if this should be exempt from that model at the beginning. And certainly we're recalibrating that. We again don't want to have such a rigid model that then ends up just being a complete loser across the board for outside counsel as well. We want it to be a positive model for everyone. And so we're certainly recalibrating that throughout the process every couple of months to make sure we've got the alignments correct there.
Yeah, I think that's really interesting. And the most important part, in my opinion, is that from an outside counsel's perspective on these things is just that, you're being flexible, but not overly flexible where it undercuts the whole cost certainty. It sounds like the way you guys have this structured is where you're really partnering with the firms that you work with in order to make it work for both sides. And I think that's just essential to alternative fees that I think are only going to become more and more prevalent across the industry as we kind of move forward through the next couple of years. Mike, I know you guys are not necessarily focused on the use of alternative fees yet, but you've undertaken some pretty unique steps to decrease litigation costs in the past few years. Can you talk through some of those and how they've worked for you, some of the steps you guys have taken as a department to decrease your litigation costs?
Sure. And I think maybe in answering that, I'd like to throw in some answers to the first part about the alternative fee arrangement. So one of the things that we focus on a lot is what can our internal non-attorney staff do that normally would be done by outside either attorneys or non-attorneys. And we try to take care of that at the front end and the back end. So we're now, I think we do about 75% of the settlement agreements. We do something like 75% of the case assessments when they come in. Before we had the capacity to cover that much, or if we have, somebody's out on maternity leave and we need extra help, that's something that we can go to an outside firm and say, let's talk about a flat fee for that section, because there you have the routinized components that you can maybe get a sense of that. I never thought of it this way, but I guess in a way we do sort of set up a fee range, but we do it backwards. Instead of settling it on it going forward, what we do is at least once a year, a guy named Ben, who might be listening in, runs an analysis. And as you know, we break up our cases into three categories. We have gold, which have a value of $15,000 or less, and then blue from 15 to 100,000, and then red 100,000 and over. And fortunately, the vast majority of our cases are at gold. So what we do once or twice a year is take a look at each firm and say, what are they doing on the gold cases? And, if they're And then you can pick out an outlier. You can say, well, this was a gold case because it really should have been a blue case. They did such a great job. It took more attorney's fees to get it down, but it was well worth it. So we know that we can do our own adjustment. And then we look at that firm and say, are we good with that? And we have, some number under 10 that we're good with that. And unfortunately, there may have been a time or two where we had a firm that say, we're looking at the last year and a half or so, and your number is high enough that it isn't just an outlier. It's sort of a way of doing things. So we're asking you to rethink your approach. And then if adjustment is made, great. And if it's not, then not. But so I guess instead of sort of setting a range ahead of time, we end up looking at the range on the back end and deciding whether we're satisfied with it. If we are, things continue. And if we aren't, then we have a conversation with the firm. But I certainly echo Justin's comment about the longer something lives, the more it costs, 9 times out of 10. And that we focus a lot on that. And as you know, so with regard to maybe alternative ways of doing things, we encourage plaintiffs' lawyers to reach out to us instead of suing us or filing an arbitration. And that was not a popular decision within my own team. I don't know, maybe not even within my own company, but for us, it seems to have worked out. And maybe that's unique because the dominance of TCPA and the fact that there's so many certain players on the plaintiff side, and that if we get out of that, it won't be able to duplicate itself. And I'll be foolish to encourage people to reach out when they have a lawsuit. But for now, that seems to work. Trend-wise, what we've noticed is, well, overall litigation filed and threatened, and I should say more so it's not, these aren't idle threats, they're going to happen. But if you put those together, our total caseload goes down 20%. But despite a 20% drop in total, we have more filed cases this year than last year. We were able the last couple of years to keep filed cases at only about 25% because we hate paying for process. We don't want to pay people to have status conferences and file meaningless briefs just because a court says you have to. And so that has increased our average attorney cost actually. But so those are, we try to measure a lot and then decide how we think we're doing and then adjust. I think that's sort of our way to try to get some of the consistency that you would see in alternative fee arrangements.
Yeah, and I think what was unique for me when I started working with you guys is just the idea that speed, get these cases resolved early was kind of, I won't say beaten, but beaten into my head pretty early on. And that, those discussions about, do we want to pay $3,000? Do we want to pay $5,000? Do we want to pay $7,000? Those discussions with your perspective really shouldn't happen because it takes time away from your in-house legal department, and it also draws out the case, creating more legal fees.
Well, the humbling but undeniable fact that I realized a few years into this is that I wasn't adding much value, and it didn't make sense for me to ask a paralegal to review the whole case, get on the phone call with her and you, and then quibble over that when we're just going to do whatever you think is a good idea anyway. But in the beginning, when we told people, if it's going to sell for $15,000 or less, don't call me. Right. Don't call me to let me know what a great job you did either. Just don't call me. Right. When you keep getting more work because you don't call me, I know it seems backwards, but we have yet to ever call anybody and say, what are you doing settling for 14? You could have settled it for 10. And our costs consistently gone down. So it's worked as much, I'm sure, because we happen to work with great people like you and Colleen. And since he's still listening, I'll throw out Zach as well. But
yeah, I think
I don't know that it worked for everybody else.
Yeah, and the part for me that was kind of interesting when we first started working together is the idea that internally you guys would do the case assessment, right? So that's something that not a lot of financial services companies, I think, take on, but it actually works really well. So for those who don't know, and most of you won't, that when I get assigned a case from Mike, I just wait, right? So there's not usually deadlines because we're out in front of the service. And I wait until the team, and it's not long, it's usually a week, that someone from Mike's team will go in and actually work up the case and give me everything I need, all of the essential facts in one document with a summary. And not always, almost always with a conclusion as to whether or not there's an issue with this case. I find it to be really helpful. And maybe it takes money out of our pocket because I'm not having an associate do it. But to me, it adds efficiency from certainly from Mike's perspective. The other thing that's kind of interesting that we've seen is the settlement process. About a year ago, maybe a year and a half ago, Mike, you guys said, look, counsel, and it wasn't directed at us, just so we're all clear, counsel generally across the country is taking too long to draft up settlement and release agreements. These are standard. We have good forms. A paralegal can just send us a term sheet with some basics in it, and we're going to draft up the settlement and release agreement. And Mike, I don't know what your thoughts are, but I think it's worked really well, and I have to imagine you guys have saved quite a bit of money.
Yeah, we track that quarterly, and then we report on it quarterly and annually, and the numbers definitely speak for themselves. And because they're listing, those people's names are Oli, Matt G, Matt B, Alex, and Alyssa.
Well, thank you guys. That was a super fast half hour. We could talk for an hour, but that's all the time we have allotted for this. So thank you all for agreeing to do this. I thought it was really interesting and always getting a great perspective from our in-house counsel partners. So thank you all. Next up, first we have our next code for the CLE. So I'm going to read that now. Code number 2 is 43612. 43612. So make sure that you are writing that down for your CLE credits. Next up, I am very happy to introduce my partner and co-chair of the Consumer Financial Services Litigation Practice, Trip Riley. Trip has more than 25 years of experience, which is a nice way of saying he's old, representing settlement service clients, including real estate brokerages, title insurers, and agencies, mortgage and other consumer lenders, loan servicers in a variety of financial services regulations, litigation and enforcement actions relating to RESPA, TILA, Fair Credit Reporting Act, FCCPA, and Dodd-Frank UDAP provisions. So Trip will be providing our fair lending update. So take it away, Trip.
Thanks, Ryan, and good morning, everybody. Next slide. I wanted to give a little context to this brief discussion, very brief overview of fair lending, fair housing. This has certainly been a watershed year, whether it is from Me Too to Black Lives Matters to all the other areas of discrimination concerns that have really percolated to the top, and thank God that they have. And then coupled with that, we have this terrible COVID-19 pandemic that we have to address, and it is clearly affecting communities of color at a much greater rate than other communities. And so you couple that with then the Bureau's move to collect more HMDA data and to determine whether or not these communities of colors are being discriminated on lending and housing. And as you'll see through this, hopefully we'll see through this presentation, that it is really going to culminate once Biden's administration gets rolling, say second quarter, third quarter, and names a new CFPB director, that I really think what you'll see is that everything that's happening at the Bureau, also at the FTC, is really going to culminate in a finite focus into fair lending and fair housing that we haven't seen since probably the Obama administration, well, certainly since the Obama administration, but I think it's going to be on steroids. So next slide. So first I wanted to talk about how COVID-19 has affected fair lending and fair housing issues, and how the federal government has, during this period, addressed the COVID-19 issue with respect to fair lending. And so at the onset of the virus, the federal interagency issued guidance, and they said it wouldn't criticize lenders and servicers from deviating from pre-pandemic standards in the course of prudent delivery of borrower relief. What that really means is we hope you don't screw up, but you know, we won't be so hard on you if what you're really trying to do is to deliver relief to these borrowers, and you're going to need to be able to establish that. And you'll see that, as they said, in providing consumer relief, there's still an expectation that you're going to adhere to the protection guidelines, including fair lending laws. So they're not throwing it out the window, these protections out the windows, but they're going to recognize there might be some hiccups there as you go along the process of trying to give relief to borrowers. And, you know, just again, CFPB itself said, we're not going to hesitate in taking public enforcement actions if we find that you've taken advantage of this time and you're discriminating in the fair lending and fair housing area. I think you also see that the CFPB, and this is going to be a theme that runs through this presentation, is that they're really fair lending extension into servicing. I think that the historically, through the Fair Housing Act, the ECOA and its Regulation B, and state anti-discrimination laws, you've seen the focus been on originations. But I think through many of the CFPB's recent actions, as well as the state actions that have focused on servicing, that the Bureau, for example, in RESPA, you know, it was very easy. It was easy to bring a case that, you know, there was some sort of kickback or something, but no one really felt injured by that. But in this servicing focus of the CFPB under ECOA, they're able to define the harm a lot easier. It's more tactile to them, and I think to the public. And so they're really focusing on discrimination as they see it in the servicing. And we'll see how some recent cases, the CFPB has tried to expand its authority under Reg B into that servicing area. Next slide. So these are just some very pragmatic underwriting and pricing best practices. These aren't all mine. They certainly, I've pulled them from a lot of sources. But if you're going to address fair housing, fair lending issues, and you're going to create a program about that, it's got to be clearly written. It's got to have objective and uniform relief program guidelines. And again, just so it's clear, this is within the COVID-19 context. And you're not, you know, disparately applying these programs or the terms of these programs. And again, uniform guidelines for applications of modified underwriting and pricing. If you're going to make changes to underwriting and pricing within your COVID-19 program, again, make sure they're uniform and make sure they're uniformly applied. And if there is a change, if you do deviate from the program you've set up, make sure you have objective reasons for it and you document it. And, you know, if there are special purpose credit programs that can be implemented, again, make sure that they're uniformly applied, show that they're necessary and appropriate in every given instance that you apply them. And most important for me, I think, is that when you create this program, everybody on the staff, from loan officers to servicers, whoever may be involved, they understand what this program is all about, and they understand how it's supposed to be applied and how it's not supposed to be applied. Next slide. On the servicing side, pretty much the same focus. Make sure that the forbearance and loss mitigation decisions centrally using objective guidelines, and that there is no discretion or very limited discretion on how those are applied. I would tell you there should be no discretion, but of course there's always the outliers. So if there is a change in that forbearance or loss mitigation decision guidelines, you pull somebody out of that, make sure that there are clear reasons that you're doing that, whether you're giving them something else or you're not giving them the forbearance or loss mitigation that they're asking for. Always communicate with all borrowers equally and consistently. No subset or different category or of borrowers should be getting different types of communications to discuss loss mit and forbearance. And I think that our other speakers have talked about the problems, and they're almost sort of amorphous right now, but coming out of the forbearance, how are you going to approach each one of those lenders? It better be uniform. It better not be driven by location or income or anything else that 6 months from now, a year from now, some lawyer or someone at the CFPB is going to say, this was an ECOA violation, this was a RESPA violation, because you really were focusing on or disparately impacting. We'll talk a little bit about the disparate impact in a little bit, disparately impacting a minority class. You should also definitely, as you go through both the COVID-19 program and as you come out of forbearance, make sure that you are testing how you are applying loss mit to make sure that it is consistent. I know that's going to be a lot of man and women hours doing that, but because of the real, I mean, I think it's a real risk when you're coming out of forbearance, how you're addressing those borrowers. And so test it, make sure that you have controls in place to make sure that nothing is slipping through the cracks. Again, so that you don't run up against some sort of, even if you get investigated or there's some supervisory conduct that's supervisory where they come in and supervise and it doesn't lead to an investigation, doesn't lead to any type of action. Again, the other thing is where you're asking for information from those who are about to come out of forbearance or that are in or they're going into loan mit or asking for it. Those questions you have to keep in mind. One, the ECOA prohibitions. You can't ask about hospitalization, public assistance, and other things. You should be aware of those requirements or prohibitions. That can be a real problem for you if you do. Certainly there's also FCRA prohibitions, seeking medical information and then using that information to establish credit reports. Those are also important areas that you need to address in any type of program, both going into COVID or while we're there, dealing with them, and then coming out of forbearance. To the extent that you have vendors doing something for you with respect to this program, make sure they understand your program, make sure they're trained on your program, and make sure that you test them. Make sure there's controls in place to make sure that they're compliant. And as I said before, any deviation needs to be documented as to why. Next slide. Just wanted to highlight the highlights, CFPB supervisory highlights. Because they really, again, they highlight the focus of the CFPB on fair lending, and that they believe that there is a ton of redlining going on with respect to lending. They have found it, whether it's in marketing, and again, this is their highlights, using only white models, using only families, using male, and sort of putting the partner, the female partner behind the scenes, These are all things that they're focused on, and I think it really shows where they are going. There is, to me, my experience is that there is a subset of fair lending people who have been around in the Bureau for a really long time. They've done their own work. They haven't been affected by the change in the administration, and they now see this as a chance to sort of right now, and actually for the last 6 months, catapult these fair lending issues to the forefront. And you'll see, I think, in a second, why that might happen. The other things about redlining in terms of lending: where's your location of your branches? Who are your loan originators? Are they all white? Are they all male? Statements made by the loan officers. And of course, you always have to be careful of the shape of your assessment area, so that when you're doing your testing and you're looking at your HMDA data, you have a clear context to put that information. Next slide. Again, this is just to say that the CFPB has found that there are lenders violating ECOA and Reg B by excluding from consideration certain forms of public assistance, which you can't do, including unemployment compensation and SNAP benefits. This is just to make sure that you understand that the CFPB finds this as a violation of Reg B. Next slide. So these are just some of the recent CFPB evaluations or developments. So in July, which is not that long ago, Bloomberg reported that the CFPB was scouring banks' books and records for potential fair lending violations. Again, just showing that this is really on the forefront for the CFPB. And then we have blog posts from the Assistant Director of Fair Lending, again, telling the public, telling you guys things to focus on in fair lending. And I'll leave you to review that list. But again, not to beat a dead horse, even though I am, this fair lending issue is of paramount concern and focus for the Bureau. Next slide. So coupled with that, we had recently the issuance of the final HUD disparate impact rule. And while I'll steal my thunder a little bit because that rule is now enjoined based on a case filed seeking to have that rule vacated in Massachusetts, nonetheless, HUD did issue this rule, and I think let me just tell you a little bit about it. So there was a lot of inconsistencies in the way in which the disparate impact analysis was administered by courts, as well as within the agency himself. So this rule, at least according to HUD, was to try to harmonize the difference of the way it was administered, and also in the way in which the burden shifting formula was dealt with in the evidentiary during the court proceeding or administrative proceeding. So the rule tried to codify exactly what the proof for disparate impact was on the plaintiff side. They have the claimant has the burden of proving under the rule that a challenge practice caused predictably a discriminatory effect. And if the claimant meets that burden, the respondent or defendant has the burden of proving that the challenge practice is necessary to achieve one or substantial legitimate non-discriminatory interests, and there can't be any other way to do it. And that's what leads to the next third burden shifting back to the plaintiff, is that no, while they claim it was necessary to achieve a purpose, there was a non-discriminatory way to do to achieve that purpose. So that was a codification, which now, if the rule were to be in place, the courts would have to follow. Next slide. So also the rule neither required nor encouraged the collection of data about protective classes. and that the absence of such evidence will not result in an adverse inference against the party. I think out of all the rule, this is the most interesting to me. I mean, obviously, that doesn't mean you don't get to follow and comply with the HMDA requirements, but beyond that, you know, a plaintiff can't come in and say they didn't really care. Look, they never even checked. They didn't test. They didn't have any controls. And this rule said, no, that's just not going to be a way in which we're going to allow a plaintiff or the government to prove their case, or at least one element of the case. Did require proof of if there is a potential that you're trying to get vicarious liability, you can't just say somebody worked for you, a vendor just works for you on a side issue. That really has to prove there was a principal agent relationship of a material basis, material relationship in order to create that vicarious liability. And as I'm running out of time, I'll just go to the next slide and leave you to read the rest. Again, we see that the NBA wrote to Ben Carson about this. They were concerned that it didn't go far enough in terms of making clear protocol. And as well as other large lenders and banks, the National Association of Realtors sent similar letters. And so ultimately, next slide, there's a challenge to the final rule. Right now, and it's not really on the substance, it was really about how the rule was got to its final form, sort of a Administrative Procedures Act claim. And of course, there was other challenges regarding algorithmic defenses and so forth. And so that's up there at the district court in Massachusetts. What will happen? Will when the administration comes in, will they just pull the rule and make this action moot? I'm not sure. I think there's probably better than a 50-50 chance that that's exactly what happens. Next slide. Now, I told you at the onset, the focus in that spectrum of fair lending has always sort of been in the origination of lending, of loans, and the focus has been there. And then I told you that there's also been a creep into the servicing, and we'll talk about that in a second. But the other creep is the other way, which is well before any origination or application is taken. The CFPB in a first-time case against a non-depository lender, and that's the Townstone Financial, brings an ECOA case allegation and basically claimed that that the actions of Townstone discouraged minorities within the MSA, which included Chicago and outlying areas, from even looking, not even applying, but even looking at Townstone as a potential lender to them. Now, I have some background in this case. Some of my good friends and colleagues are actually intimately involved in defending Townstone. So some of this comes from that. What I can tell you is that the CFPB, well before they filed this action, did 2 years of investigation. And not an abnormal investigation, regular investigation, took depositions, took a ton of documentary discovery through CID, very intrusive CID. And I would tell you that I think that the evidence showed that, let me also tell you is that the Townstone went to a unique position, and they went out and they hired 2 vendors to do and review the HMDA data. And both of those vendors came back and said there is no racial discrimination and no disparate impact by anything that they did. In fact, the opposite they found. The Bureau didn't agree with any of that, even though they didn't have their own contrary research, and they filed suit. Next slide. So look, the allegations sound terrible. The statements that they made about the neighborhoods and about the people in the neighborhoods, taken in a vacuum, I can certainly agree with you that they sound terrible. We'll just have to see how it comes out. But I can tell you that the investigations that they did pre-litigation, the members of the MSA and the African American community actually said that those statements were just they were true about the community, and that allegations about the jungle jewel was actually a term that was used in that community to talk about the supermarket that was there. Anyway, I'm not going to get bogged down in that, but the point here is that, and this is not unique, the ECOA has been used to allege, or violations have been alleged under here for discouraging prospective borrowers in the past. But typically that has been a depository lender. This is a small, very small, non-depository lender. So it's just an interesting case that they are really pushing this agenda, even though they have pretty strong counter evidence from the defendants. Next slide. So just to tell you where it is, Townstone filed a motion to dismiss in lieu of an answer. There's where you can see what their arguments were. I think some of them are rather difficult given the historic cases that ECOA can apply and Reg B can apply to cases in which the plaintiff or the government is alleging discouragement. But given that a lot of these statements were made on a radio station and was a political radio station, there is at least an argument to be made here on the First Amendment. Next slide. But instead of sorry, went a little bit too quickly, but instead of responding with opposition to the motion to dismiss, the CFPB filed amended complaint. They changed none of the allegations. They didn't enhance any of their discouragement arguments. Rather, what they said was the owner of Townstone moved money from his company into another bank account, and that was a fraudulent transfer, and that he knew that he was going to get tagged with a judgment in the end, and therefore the Bureau wants to have all of that money brought back into the company. But interestingly, the company still runs, it's still lending, the money is still being that money that he moved out of the company is still being used to fund any ongoing operations that the revenue itself isn't funding. So it's a little bit of an interesting move on the CFPB's part. I'm not quite sure what they thought they were doing, but that's where that is. And I'm getting towards the end, and this is my point. So there's going to be a new director of the CFPB, and one of the people that is considered as being at the top of the list is Patricia Finklin, and she right now is the director of fair lending. And so, and she's, all of these actions we've talked about and all the comments about fair lending from the CFPB is coming out of her office. So I think you're going to see in the third quarter, fourth quarter of next year, fair housing, fair lending enforcement actions ramp up. Whether Patricia is confirmed or not, or even nominated, I think you're going to see that. And I think that the Townstone action, and I think some other actions by the CFPB show this. And one which is not in my presentation, but we'll give you a copy of the amicus that the CFPB filed in T-Winkle versus Capital One. This is an ECOA claim. And it's all about servicing. And the plaintiff in that action said, look, I didn't get notice that you were going to terminate. I didn't get notice, and I didn't get the required description and reasoning that ECOA requires for closing my account. And the defense, Capital One's defense is, no. ECOA doesn't apply to servicing. It only applies to the applicant of a loan. And the CFPB has argued in its amicus brief that applicant, that definition of applicant includes the borrower at the time that the loans are being serviced while the account is still open. So it doesn't have to be actually a loan, it can be an account, and it could be a standard loan. But while that's still open, there's certain aspects of ECOA that still applies to an applicant, and that applicant's the definition of that applicant is while they have that account open or the loan is being serviced. I've read the amicus brief. It seems clear that ECOA's definition of applicant does apply at certain times and certain aspects while the loan is still or the account is still open. I'm sort of surprised at the defense, but I guess you have to put up a good defense or some type of defense. But to me it triggers the notion that the CFPB is going to focus on fair lending in the next few years at a heightened level, and that they're looking at an application of all the fair lending laws to pre-application for credit, at the time, and then post. And I think that is consistent with what we also see at the state level. Next slide. So that's the end. And so my takeaway is I think we're going to see a tremendous amount of fair lending enforcement actions, investigation and enforcement actions. And that's going to open up, I think, the floodgates to private class actions and private one-off litigation. But thank you very much.
Thanks, Trip. That was terrific and continues to be an extremely important issue for all of our clients. We have our final code, so please go ahead and write this down. Code number 3 is 93162. 93162 is the final code. I'm happy to introduce our next presenter, Jen Vidal, who is going to bring us home. Jen is the current co-chair of our White Collar and Government Litigation and Enforcement Group. She is a former federal prosecutor in the Southern District of New York. She regularly counsels financial services clients who find themselves in the crosshairs of federal, state, or local criminal enforcement authorities and conducts internal investigations for a variety of clients. So Jen, thanks so much, and over to you.
Thanks a lot, Ryan. Happy to be here with all of you today, and hopefully hoping to bring it home here in a productive way. First of all, can you hear me and see me? I think I have my video on, but I don't see myself.
Jen, we got you.
Okay, sounds good. So we're wrapping up the day here with ethics, which I'm sure everyone is happy to get the credit, but it's not the most exciting topic. So I'll do my best to wrap us up here in a positive way. So moving to the next slide here, we have really 2 agenda items that we want to talk through. One is how some updates on ethics in an increasingly electronic world, and what are some relevant groups saying about how social media and similar things are going to affect all of our ethics. And then we'll move to some ethics and internal investigation. So to that electronic world piece first, we can go to the next slide. The American Bar Association and some other regulators on ethics are increasingly saying things like this quote, that lawyers can no longer claim ignorance of technology as a defense for not knowing something or doing something that they otherwise should have done. And this is being applied at all levels. If we look at the next slide on the rules of professional conduct and Rule 1.1 on competence, we see an insertion relatively recently there talking directly about the benefits and risks associated with relevant technology and how we all need to know about that. And then if we switch to the next slide, we'll see the Pennsylvania Bar Association, by way of example, has talked specifically about the obligation of competence now extending to lawyers specifically understanding their clients' use of social media accounts, the privacy issues that arise from that, and their clients' obligations to preserve information that might be relevant to their legal disputes across social media platforms. And so that's the typical Facebook, Instagram, Twitter, but then, we really do have to think about ways in 2020 that our clients may be messaging across, whether that's BBM or a messaging platform on Facebook or whatever it is. We have to be in a position to collect and preserve information through all of those platforms. Email just isn't good enough anymore. And so we'll talk through that a little bit more detail, but from the perspective of in-house folks, really a policy play is the best way to start here. If you have policies saying that employees should not be using social media or anything outside of a curated set of programs or platforms for purposes of their work, then you can rely on that policy in part when you get into a litigation dispute and need to collect materials and say, reasonably, we did not go beyond, Outlook and our internal communication app because we've instructed people not to use other things. There are some courts that may press you further than that, but a policy play is really important here so that when you want to narrow the scope of collection, you have a leg to stand on to do that. So a little bit of a review here, probably for most of us on e-discovery, if we turn to the next slide. We have Zablocki as really still the leading case on this area, which basically says that parties have the duty to preserve digital information when there's an acknowledged chance of litigation existing. So now digital information in 2020 is different than digital information when this case was originally handed down in the early 2000s. And so, then Zablocki was really talking about emails largely. Now it means social media, all these forms of alternative messaging. And so we really have to make sure to get mechanisms in place to preserve all of that to the extent it exists whenever there is an acknowledged chance of litigation. And a lawyer has a duty to monitor the client's compliance with litigation holds and preservation efforts. And there should be some sampling mechanism, according to the Zablocki court, in place so that we can communicate to the court our efforts to understand the costs associated with data recovery and preservation, and also the effectiveness of the processes that we have in place. So these standards, again, made sense when applied to email, and were at least easier to implement when applied solely to email. Now that we're expanding them to more things, we have to think about whether our litigation holds, for example, cover all of those other things. Have we communicated the expectation with our clients that, let's say we have a policy that says no communication on social media about work topics, and yet an individual employee at a client has done that. Does our litigation hold communicate to that person that we're also asking them to hold that particular communication on social media, even though maybe that was outside of the company's policies in the first place? So all of this just gives folks more to think about in terms of really, are we preserving materials thoroughly enough in 2020 when every day someone else is coming up with a new platform on which to communicate? How does this tie into the ethical rules so that we can get you all some ethics credits? If we turn to the next slide, we see Model Rule 3.4 talking about fairness to the opposing party and counsel. Obviously, discovery obligations tie into this rule. You have an obligation to preserve information that is expected to be relevant, and you have to make reasonable and good faith efforts to do that. What's reasonable and what's in good faith evolves all the time. The more we have experiences where our clients are communicating on alternative platforms, the more reasonableness and good faith efforts dictate that we go to those platforms to engage in preservation and to make collections. So the point here is this will continue to evolve, and we have to continue to evolve with it. We can't keep sending the same exact litigation holds and making the exact same preservation efforts. It really does have to evolve with the technology. And then this ties into Federal Rule of Civil Procedure 37E. which applies when electronically stored information that should have been preserved in the anticipation of litigation is lost because the party failed to take reasonable steps to preserve it, and we can't restore it or replace it through some kind of additional recovery. So that sanctions mechanism could be applied to things that were not preserved in email. It could also be applied to things that were not preserved on social media. And again, we expect that sanctions mechanism application to also evolve over time, so that when, again, it becomes more normal, for example, for clients to communicate over Facebook Messenger, then if you fail to preserve messages on Facebook Messenger, it's more likely that this sanctions mechanism will be applied, you know, in that future time than say 10 years ago. So again, we just want to be in front of all of this. You know, you don't want to be the first person in that landmark case where there's a sanction imposed for failure to preserve something on social media. So, you know, this is evolving policies, evolving litigation holds, evolving scripts for custodian interviews when custodians are identified for collection purposes. We want to be sure we're asking them about all the ways in which they communicate that could possibly be subject to preservation on social media, on alternative messaging sites, etc. If we go to the next slide, I found this interesting survey saying that 95% of federal judges in this one study said that they want to see greater participation from in-house legal teams in all aspects of e-discovery. And that went on to say they'd love to see in-house counsel in meet and confers. They'd love to see them involved in the e-discovery process in terms of helping to select custodians, search terms, etc. The rationale behind that is obvious. The folks that are in-house likely know the ways in which documents are stored in a more intimate way than outside counsel knows it. And so I think this expectation from judges signals that they want to make sure that things are collected and preserved with the best possible slate of knowledge in play at the time that those decisions are made. So, you know, if something got to a place where there was a sanctions consideration, for example, I think a plus factor for the defense side of that would be to say, you know, look, we involved in-house counsel from the outset. We analyzed the way that documents and information are kept at the company. We preserved them in this reasonable and good faith way. You know, we consulted with in-house counsel on a regular basis about all of the steps, search terms, custodians, et cetera. And now we are at the place we're at. So all of this to say, you know, I think this really needs to be a collaborative effort going forward so that we're working together to make sure that everything's preserved in the way that the courts are expecting. So the bottom line here, if we turn to the next slide, is that lawyers have the responsibility to ensure that the client retains documents appropriately, ensure that the relevant players know about that and follow it, and that all leads to a place where there are responsive documents to produce in discovery. So a couple hypotheticals we have here for you to keep things a little more interesting than me just talking about ethics. The first one here, your company will be migrating its existing email platform to the cloud. Your longtime IT director is highly competent and always completes upgrades and big IT initiatives without a hitch. So what is your role as inside counsel in that process? And we have some choices for you to choose from. And if you want to put your answers into the chat box, we'll take a survey of what you all think is the most appropriate answer. A, review the contract with the cloud service provider for data privacy issues. B, meet with the IT director to ensure he or she understands that some documents may be subject to holds and can't be purged. C, require the IT director to draft a step-by-step plan identifying which documents will be preserved and how they'll be migrated, and then conduct a follow-up audit to ensure that that all happened correctly. Or D, you didn't really learn about this until you got an email saying that everybody's emails are going to be inaccessible for 24 hours while all this was happening. So if anybody wants to vote on their answer, we can take an informal poll on what folks think, but I won't hold you in suspense, and you probably all know the answer anyway. If we move to the next slide, what we're recommending is C, which is work with the IT director to make sure he or she has a step-by-step plan, identifying the documents to be preserved, how they'll be migrated, and then audit that procedure to make sure that it happened. So let's say there is a plan, there is an audit, and something is lost. At least that's a defensible position, because recall that all we need to do is show we made reasonable and good faith efforts to a court. So if there's a loss of data that's later responsive to something, in that situation, you would be able to say, look, we had a plan. These were the steps of it. We audited the plan to make sure it worked appropriately. In doing that, we learned some technological failure happened, and that's why we ended up where we are. That's the best way to show reasonable and good faith efforts when faced with this kind of situation. So another hypothetical here for you. A former employee is suing your company for discrimination and harassment. The employee states there's evidence for the claims on the company's Facebook page. Your communications director suggests changing the Facebook page status to private and deleting the posts in question. What do you do? Is it appropriate to direct the page, to change the page operator to change the status to private? And is it appropriate to delete the posts in question? So this is obviously an open question in some jurisdictions. This is an evolving area. I'm just going to show you some guidance from some jurisdictions on what to do in this situation. So if we turn to the next slide. The Pennsylvania Bar Association's Ethics Committee, for example, has issued some guidance saying a lawyer may not instruct a client to alter, destroy, or conceal any relevant information, regardless of form, basically. But the lawyer may instruct the client to delete information that may be damaging from the client's page, provided the conduct does not constitute spoliation or is otherwise illegal. So you have to preserve it. What does that mean in the context of the hypothetical? What I think it means is, if there's something if there's a page that's public that should be private, or if there's content on a page that should not be there, the status of that all needs to be preserved first. So we need to have a defensible copy of what existed, and then we can make appropriate changes going forward. So then we can, we preserve it first, then we can tell folks to take it down or change it. But we really have to make sure that that kind of advice is not spoliating evidence. So this all has real world ramifications. The Virginia State Bar's disciplinary board, for example, suspended an attorney for 5 years for instructing his client to delete certain damaging photos from the Facebook account, withholding those photos from opposing counsel, and then withholding from the court the emails discussing the plan to delete the information from the client's Facebook page. So in reviewing all of that, Virginia State Bar's disciplinary board said there needed to be a 5-year suspension, $722,000 in sanctions, about $500,000 of which were on the lawyer, and about $200,000 of which were on the client, to compensate opposing counsel for their legal fees. If all that had happened there was that the lawyer had instructed the client to take down the damaging photos, that would have been fine. It probably would have been a good move for the client going forward, but they needed to be preserved. They needed to be shared. And you can't hide behind the attorney-client privilege to accomplish that kind of goal, is what the court said. If we turn to the next slide, how do we avoid a mess in this area, basically? And how do we get to say to a court, I'm reasonably confident that I collected everything? We talked about policies. We need to have policies in place that say, communicate on appropriate channels, don't communicate elsewhere. We need to train our folks on those policies and have codes of conduct that involve potential employment ramifications if folks are not following those policies. And probably most importantly, we need to actually spot check and have a pulse on whether that's happening. if, for example, you have a policy that says no external communications outside of email and some internal messaging system, but then a pretty open and obvious pattern happens where 99% of folks at the company are communicating across Facebook Messenger, for example, it's not going to be enough to hide behind that policy. That will have been open and obvious. Courts will likely say you should have seen that sooner and stopped it. So, it's really policies, training, and checking on those trainings. So if we move forward a slide, I want to shift to ethics in internal investigations, which is an area I spend personally a lot of my time focused on. And so we have this cartoon here, which illustrates a point that we sometimes run across in internal investigations on a regular basis, which is, what if you have an internal conflict of interest among the team that would otherwise be involved in or run the internal investigation? This conflict in this cartoon is a pretty extreme one. You see here that this CEO says that the executive compensation committee approved that he both be the CEO and also a pirate who kidnaps employees for ransom. Don't think we're ever going to run across that one, but we all could run across a situation where the CEO is the CEO and also is being asked to investigate conduct that he or she had some role in. And so a lot of what I want to talk to you about in terms of ethics and internal investigations focuses around that. How do we get the right team doing the right things, making the right decisions when we're going into internal investigations? So can we shift to the next slide, please? This is at a high level the topics we're going to talk about today in terms of ethics in internal investigations. What are the ethics around deciding if an investigation is needed? If we decide an investigation is needed, how do we decide ethically who should investigate? We want to keep an eye on who's the client for purposes of the internal investigation. And then how do we make sure we are appropriately maintaining privilege while we're conducting that investigation? So let's turn first to how do we decide whether we need to investigate something? So obviously some investigations are proactive and some are reactive. Sometimes we choose to investigate because there's a regular internal audit that's conducted, or we have a compliance officer in place that says we need to do a certain type of investigative work. More often though, they're reactive to something like a whistleblower complaint or an EEOC complaint or some kind of internal HR grievance or concern. Maybe they're reactive to a subpoena that we get from the government, whether that's civil or criminal, or some other kind of regulator contact. Also, obviously, as we go down that list from top to bottom, the reason for investigation and the need for investigation becomes more serious. So if you're getting a regulator contact about a particular issue or a criminal subpoena about a particular issue, it's pretty obvious that some investigative work usually needs to be done around that issue. There are exceptions to that. Sometimes a criminal subpoena obviously calls only for some subset of information where, for example, the client was the victim on some transaction or has some curated set of information relevant to some investigation, but the client doesn't have any particular risk. But probably 9 times out of 10, those kinds of contacts mean something needs to be investigated. And usually, HR grievances or whistleblower complaints could lead to the same result. But there's never anything in an internal investigation that is one size fits all. So again, sort of working down that spectrum, there are some more minor complaints or concerns that maybe arise internally and can be handled internally by an internal team. And then there are some more serious regulator contacts and government subpoenas and things that require likely an outside team that maybe is walled off from certain parts of the inside team for whatever reason. And those are all things that need to be thought out and intentionally decided whenever these kinds of situations arise. If we turn to the next slide, it's helpful in making the decision of whether to investigate to think through what the goals of an investigation would be in the first place. So no matter the source of a complaint, whether it's internal HR or coming from the government or whatever else. The primary goal of the investigation is to determine whether the allegations at issue have merit. If you already know the answer to that question with certainty, maybe that counsels against the need for an investigation. If you look at an allegation and think, wow, I really have no idea whether this is truthful or not, likely an investigation is more necessary. Another goal is obviously to rein in the scope of the conduct. Sometimes the scope of the conduct is apparent on the face of the complaint. Sometimes it's a very narrow issue that you can scope from that. Other times, maybe there's a very specific thing that's being complained about, but there's a real concern that that same issue could go over into different accounts or different clients or different, business segments. The broader potential scope is another reason to investigate. Another goal of an investigation is obviously to recommend remedial measures that should be taken against individual employees to prevent this kind of recurrence and to limit liability, and also preventative steps that are needed to avoid future incidents. So again, looking at the face of a complaint, one of the things to think about in terms of whether you need an investigation is this the kind of situation where we need to take employment measures against someone? And is this the kind of situation where we maybe need to take preventative steps like changing a policy or implementing training or something else to avoid this kind of incident happening in the future? And obviously where you do need HR measures and policy changes, it's better to do an investigation so that you make sure that those things are implemented in a way that is thorough enough to address the whole problem. And then the last goal of investigating is to be in a position to address whatever future risks arise around the topic of investigation, whether that be the government separately investigating, separate civil litigation arising around the problem, or some public relations hits to the company that could arise from the problem. If any of those things seem like possibilities on the horizon, it's always better to know more about what the issue is and be proactively managing it before the government knocks on the door, before you get that civil litigation. And so again, that would counsel toward starting an internal investigation. So now the question is, who should do the investigation, which we'll talk about on the next slide. So turning back to the model rules again, rule 1.7 on conflicts has a comment that says, the lawyer's own interests should not be permitted to have an adverse effect on representation of a client. With that rule in mind, we need to decide who is the decider on whether to investigate in the first place and who should actually conduct that investigation. So focusing on the conflicts comment, hypothetically speaking, let's say the complaint centers around conduct that could have involved the direct supervisor of the general counsel, for example. In that circumstance, it's possible that a general counsel's own interests in protecting his or her boss or in not being seen to be an adversary of that person could cloud the general counsel's judgment on whether to decide to investigate and also in the course of conducting that investigation itself. So in those circumstances, that counsels towards engaging someone on the outside to conduct the investigation and maybe referring to a board or some other management level the decision on whether to investigate in the first place. So when investigations that are sticky like that and that involve high-level management arise, we just always want to make sure we're taking a step back and making sure that no one who's within the decision team has any potential of conflict. And if so, we need to go a different route. So if we turn to the next slide, some other factors suggesting you might need to go outside with an investigation. We talked about the potential for in-house counsel to have some kind of conflict given an investigation reaching high-level places, or the potential for in-house counsel not to be able to give detached advice, maybe because the issue being investigated investigated is something that in-house counsel already advised on. So we obviously don't want to be in a position to investigate ourselves or our supervisors in any way. Sometimes the position of the individuals under investigation counsels having someone outside, just because from an internal perspective, it's hard to be working with people one day and investigating them the next. And it's easier for someone on the outside sometimes to be able to do that. Higher level risks like government scrutiny, potential criminal conduct, the need for expertise in dealing with a particular government agency or office, all counsel toward having someone outside that signals to folks that this is being treated differently than a more run-of-the-mill complaint, and sometimes can lead to a better result. And then obviously, if in-house resources are consumed elsewhere, that counsels toward bringing folks in to assist on the team. So turning to the next slide, regardless of who the team is or ends up being, it's important to define the scope of who's doing what and what the representation means. So whatever part of the in-house team is participating in the investigation needs to have a defined role for doing that, especially in interviews of employees. So in this context, it's important to segregate a legal function from a business function to make clear that the folks on the in-house team are doing a purely legal function in conducting the interviews. And, even though in-house counsel A is 20-year-long friends with witness B, in-house counsel A is not a lawyer for witness B. They're here in a defined role to investigate a particular thing, and that's what's happening. It's important to make all of that clear at the outset. And then if outside counsel is engaged, it's also important to define the client of outside counsel. Is it the company? Is it the board? Is it a particular committee of the board? Is it some other related entity within the organization? All of that becomes important later from a privilege standpoint and from the standpoint of to whom do the results of the internal investigation get reported? Who's the decision maker on the outcome of the investigation? This can get muddier than it seems. Let's say the client of the outside counsel is a committee of the board, but then the CEO needs to be interviewed for purposes of the investigation. Well, now the CEO knows about the investigation, likely has opinions on it, likely has input on what should happen as a result of that. Outside counsel needs to stay focused on the fact that the board committee is its client and needs to make the ultimate call and not be swayed by, the thoughts and views of the CEO in that particular circumstance. This segues into model rule 1.13, which is on the next slide, and asks us to ask the question, who's the client? This is the rule on having the organization as a client, which we know says a lawyer employed or retained by an organization represents that organization acting through its duly authorized constituents. So we all know if we're engaged by an organization, we represent the organization, but then the organization is just a legal fiction. It only can operate through, its high-level officers and directors and employees. And so even though that sounds easy to say, it sometimes becomes hard to implement and hard to, advise people that we're interviewing about where the scope of their conduct falls. Do they need counsel? Can we answer particular legal questions they're posing to us? So when any of those issues arise, we need to take a step back and make sure that we can answer them in ways that are consistent with the fact that we represent the organization as the client, not any of those individuals. So we have a hypothetical here as well. In the course of assisting an executive with a matter, you come to believe that the interests of the executive do not align with and may even be adverse to those of the company itself. What do you do? So the answer here is you have to make sure to keep reminding yourself that you have to proceed as is reasonably necessary in the best interest of your client, which is the organization, not that executive. So in that context, you may need to explain to this executive that you don't represent them, you represent the company. You may need to encourage that executive to engage separate counsel. You might even need to refer the matter to someone else off of the investigation team, maybe go back to the board or a subcommittee of the board to ask their view on what to do with respect to this executive. Because the muddiest line is if an executive engaged in conduct that was appropriately within the scope of their employment, and if they have any level of legal sophistication, they're going to appreciate that in some ways company counsel will be able to advise them about that within the scope conduct. But whenever we're in a situation where there is an internal investigation in the first place, there's always the likelihood of outside the scope conduct or conduct that was not authorized. And so we don't ever want to look like we've given legal advice to someone who was not the client, especially if that legal advice conflicts with the needs of the organization as the client itself. So again, there's no one size fits all result here. Excuse me, I don't have COVID, I swear, it's just allergies. And I don't know of any virtual transmission means for COVID anyway, so you all should be fine. So we just want to make sure that in all situations, we're making decisions that are defensibly within the scope of our representation of the organization and can't be seen as giving legal advice to any individual executives, especially where their interests don't align with those of the client. So it's important to take a step back and think about who might not be the client in the context of an internal investigation, and that's on the next slide. So employees with respect to their own personal interests. So in the scope of conducting an investigation, interviewing employees, some employees don't regularly have any opportunity to interact with lawyers. I've had situations where they say, hey, oh, by the way, what do you think about the benefits plan that says XYZ? Obviously, that they're not the client with respect to their personal interests like that, and we can't be giving them advice about those questions. Employees that have objectives that are different than the company's might not be the client. So there might be an employee that supervised someone who engaged in potentially criminal conduct, for example. That employee might have an objective to go to the government and cooperate with the government to make sure that they don't have individual criminal exposure, or that if they do, they've managed that by becoming a cooperating witness. That's someone that company counsel cannot give any advice to, and that almost certainly needs separate counsel to advise them on their risks and the benefits of proceeding in that way. Interviewees in an internal investigation might not be the client, usually always aren't. Former employees, pre-termination communications with those employees are likely privileged, but post-termination communications are likely not. So it might be that someone who's key to an investigation recently left for totally innocuous reasons. Maybe they retired. You might have the inclination to reach out to them and ask what they know. Keep in mind that those communications post departure are likely entirely not privileged. And so, that in particular is an area where it's important not to be sharing the facts of that investigation with those individuals. So one public example of somewhat of a snafu in this regard is in the Sandusky scandal at Penn State. So Cynthia Baldwin, who was the then general counsel, you may have read in the news, attempted to represent the president of the university and 2 other top administrators in her capacity as the university's general counsel. She interviewed them. She told them they could get their own counsel. She told them that her conversations and her work for them would not be protected to others within the university. So she told them that the privilege was held by the university. But where she went wrong, according to the court, was that she did not make clear that in the event of a future split of interest between those individuals and the interests of the university, she would be loyal to the university. And for example, if the university was directing her to talk to prosecutors or to testify before a grand jury about what they told her, that's what she was going to do. The court found she didn't clearly enough say, Graham Spanier, if it comes right down to it, I'm going to go with the university as my client. So then what ultimately happened is she represented Graham Spanier and the other 2 individuals in the grand jury. And in the context of that, she revealed some information about her work for them to state prosecutors that were working the Sandusky case without going to those individual clients and asking them for a waiver, because in her subjective view, her client was the university and the university had authorized her to make that disclosure. So then when ultimately the 3 individuals were criminally charged, Pennsylvania Superior Court threw out some of those criminal charges because the Superior Court found that those 3 individuals had been effectively denied defense representation because they thought that Baldwin had undivided loyalty to them when in fact she was working for the university. What's most interesting to me about that is that she got it really almost right. She told them they could get their own counsel. They decided not to. She told them that the privilege was held by the university, but she didn't go that extra step to say, oh, and by the way, if this gets to a conflict, I'm choosing the university over you. And so I think that's a really interesting example, because there are a lot of people out there conducting internal investigations that are getting it almost right in that same way. And so it counsels toward just really thinking through what all the potential divergences of interest could be in the future, and whether in that context we're advising the people that we're interviewing appropriately. In almost every circumstance where the person you're interviewing has some potential to have been either involved in or supervising the conduct being investigated, company counsel probably cannot represent those individuals. And so, underscoring these issues is really important in those circumstances. If we flip to the next slide. So how do we do that? We've all heard of Upjohn, which is essentially the same as corporate Miranda. So when we're interviewing an employee, we need to provide them with a warning that says, we represent the company, we don't represent you. The purpose of the investigation is to advise the company and not to help you. The privilege belongs solely to and is controlled by the company. And then this last one is the one that Cynthia Baldwin, the court found she missed. The company may waive the privilege and disclose it to any government agency or any other third party at any time. And as part of that, the lawyer for the company might be involved in that disclosure. So I don't represent you. I'm doing this representation for the company. That's why I'm investigating. They have the privilege. They can waive it at any time. That's an effective Upjohn warning. So we need to give that to witnesses, and we need to document in the notes of those interviews both that we've given it and whatever reaction they have to that Upjohn, if they have one, so that if this becomes an issue later, we have a written record of that warning and the reaction. What if you give the Upjohn and the person says, oh, well, I do want counsel? Well, then we need to stop the interview and reschedule it and get counsel. Or we need to wait for that employee at a later time to say, you know what, I either consulted with counsel or chose not to, and I'm happy to proceed talking with you without counsel. And then we need to document the fact that that happened, so that again, we have a clean written record of everything that's happened with respect to counsel issues and Upjohn with respect to this interviewee. That all sounds very formal, but there is an art to delivering this in a way that's not scary to a witness that's never heard it before, and that doesn't make every low level, employee think, oh my gosh, I have to go get counsel. And so, we need to hit all these points, but we need to deliver it in a way that says, this is a standard thing I tell everybody. This is no reason for you to be individually concerned. I'm not aware of any, so long as this is factually true, I'm not aware of anything individually suggesting that you need to be concerned with any of this, but, these are the 4 things I'm advising you about. So I'm not suggesting, it behooves anyone to walk into an interview and scare people, or deliver this in a way that is very formal, like a police officer delivering Miranda rights. We can deliver it delicately, but still hit all the points and document them appropriately. So this plays into Rule 4.3, which is on the next slide. And this talks about clients who are unrepresented, dealing with unrepresented parties. So tying Upjohn and everything into an ethical rule, we can think about the interviewee as an unrepresented party, and we can look at Rule 4.3 as a reason why we have to do Upjohn from an ethical rule standpoint. We can't imply that we represent an unrepresented party if we have reason to believe that the unrepresented party misunderstands our role in the matter. We have to clarify that in a reasonable way. We can't give legal advice to an unrepresented person other than the advice that they should secure outside counsel. So Upjohn ties into this rule in that way. So I wanted to make sure to ground us in that. That leads to some interview best practices that we try to implement and advise folks on, which are on the next slide. It's always important to have at least a 2-person interview team in every interview, so that if there's ever any dispute as to whether an Upjohn was appropriately given or an individual asked for counsel, we have a witness there to that. We can't give people legal advice. We don't want to overshare facts with anyone. This is not a two-way street. I'm often asked for facts in interviews of witnesses, and I just explain to them, I'm sorry, this isn't like a normal conversation in everyday life. I unfortunately can't share those things with you. And usually that satisfies them. We want to prepare written notes of the interview, noting, as I said, that we gave an Upjohn and how the employee responded, including noting that we explained that the privilege was held by and waivable by the company. And then within those notes, we want to make sure we include both facts and attorney opinions, observations, and impressions. We don't want to be taking notes that are a transcript of the interview, because if we do them as a transcript, they're discoverable. The fact that it's an interview conducted by a lawyer doesn't make it doesn't privilege the facts. What's privileged about it are my and your opinions, observations, and impressions of the witness, how that plays into the investigation. That's what's privileged. And so the best chance we have of keeping our notes privileged is keeping a version that sort of keeps those things mixed together, that a court hopefully later isn't going to make us parse through. So don't take transcripts of interviews unless you are confident in turning those over later. And, in my experience, folks who are involved in conduct that's improper very rarely fully explain that the first time. So keep in mind that if you keep a transcript of what a witness did when that witness has potentially some involvement in criminal conduct, there's likely going to be an evolution of what they're willing to say around that. And now you've just documented the fact that they didn't fully tell the truth the first time. Sometimes maybe you want to do that. I'm not saying that's never appropriate, but just know when you make that decision, that's the implication. And then We would counsel against sharing those notes with the interviewee or your whistleblower for purposes of keeping the interview team insulated and the best chance of maintaining your privilege around it. Now, what if the interviewee requests counsel? We have that on the next slide. What if they request a union rep? You should be respectful of those requests and stop the interview and proceed only with, counsel present or written waiver, as we've discussed before. You can consider if joint representation is appropriate or if representation of a group is appropriate. Not every single employee needs fully separate counsel. There can be groups of employees who have similar exposure who can be referred out to, one counsel that works with one group and another counsel that works with another group. That's what we do most of the time in the white collar space. And that's how we get the best information sharing and the best strategy across the board for everyone. So, it's not as if you have to stop and get everyone an individual counsel, but it makes sense to take a step back and give folks time to get what they need and do the interview once you're comfortable that they have what they're asking for from a counsel perspective. Just a couple more slides on the privilege. How do we maintain it in the context of an internal investigation? We want to clearly label the fact that there's legal advice in whatever documents we're maintaining, whether that's notes of interviews, whether that's bullet points of findings, reports. We want to include attorney impressions and opinions, not just facts. And we want to make clear that we're doing this investigation in anticipation of litigation, because that's how the work product privilege is going to attach. If we're just investigating because we want to make sure that we have the best possible compliance, that's not the same as investigating in anticipation of litigation, and a work product privilege may not attach to that investigation. So if we are investigating in anticipation of litigation, we want to make sure that's clear on the documents that we're maintaining and circulating. And we want to indicate confidentiality on those documents too, because if we create a document that's intended to be made public, then it's not protected by the privilege. So if we create a report, for example, of an investigation, and we're emailing around saying, here's the report that we're gonna give to the Wall Street Journal that vindicates us, courts are not gonna find that privilege. So if we're creating internal reports for internal purposes, we wanna make that clear in all our communications about those documents. And then we wanna ask ourselves the question on the next slide, who is within the privilege bubble? So some states, a minority of states, use the control group test, but most of the states in issue use the subject matter test. So the control group test says that the privilege involves only those employees who communicate with counsel and who are in a position to control or take a substantial role in the determination of the course of action a corporation may take based on the legal advice received. So if you're in a control group test state, you need to have a much smaller group of people involved in your internal investigation if you want to maintain a privilege over it, because it really has to be these folks in a control position to maintain the privilege. But if you're in the other states, then the subject matter test applies. That's controlling in federal courts and in most states. And it basically says that the privilege attaches when the communication is made for the purpose of giving or receiving legal advice, and the employee who's communicating with the attorney is doing so because there's an attempt to obtain legal advice for the corporation, the subject matter of the communications within the scope of the employee's duties, and the communication is not disseminated beyond those persons who, quote, need to know. So need to know is really the shortcut way to think about this. Under the subject matter test, we need to be communicating about investigations only with those people who need to know. That could include consultants like financial advisors. It could include PR firms, but whoever we're communicating with, we need to engage with them appropriately and only to the extent that they need to know. That often counsels toward creating separate reports or documents for separate groups for separate reasons. So maybe there's one report that's more fulsome that goes to the board committee on whose behalf or direction the investigation was conducted. Maybe there's a separate document that just lists corrective actions that goes to HR, for example. So at every juncture where we're thinking about communicating with some other group, we have to make sure that that group needs to know the full extent of what we're communicating to try to avoid a waiver. And if not, we have to tailor some other message that's directed just to that group. Last slide I have is practical advice on how to avoid a waiver. The first one we've just talked about, control with whom you communicate and who's present in those communications, and think about the need to know concept. Control what's discussed as we've talked about and tailor that to the group. Control how you're having those communications and how you're documenting them. So oral communications are sometimes preferable. All documentations need to be thought through the lens of privilege and whether we're waiving it. And then when we're thinking about how we communicate, label the communications appropriately, the fact that they're privileged, the fact that they're work product, and always consider the email forward. If you analyze the control group, decide who needs to know, send an email to those people, all of those people can easily forward that to their whole team if they're not directed not to do that. And then even though we've thought through all of this, we end up waiving anyway. So that's what I had prepared for all of you. I know we only have a few minutes left. Happy to take any questions if there are any.
Great. Thanks, Jen. Doesn't look like there's any questions. Let it be noted that Jen did the heavy lifting today. She not only had the longest presentation, which we needed for ethics and CLE purposes, she had no help and unbelievably found a way to make a CLE presentation interesting. So special thanks to Jen for taking that laboring oar today. That concludes today's webinar. Thank you again for all of our panelists and speakers, and remember to keep an eye out for the thank you email, which includes links to the program materials, the recording, and the CLE survey, which you will need. Finally, if we didn't get to your question, we'll do our best to send a response via email. In the meantime, feel free to reach out to any of our presenters with any questions. Thanks, stay well, everybody, and happy holidays.